All right, ladies and gentlemen, I have about 9 o'clock. We're going to go ahead and start calling the dockets. I will begin with the Frio County docket. Ask for announcements from everyone. In the interest of Jacqueline Chavera, a child. All right, Dahlia at Frio County, have we heard anything from Mr. Ramirez?
Judge, I'm sorry, I have a new headphone, but that case was dropped. They're going to reset that on request.
All right, thank you.
Thank you.
I couldn't hear you at the very beginning. So is that the first case you called, Judge?
Yes.
Okay.
All right. Atascosa County, in the interest of Micaiah Rodriguez, a child.
Yes, Your Honor, I'm present on that. My client is running a few minutes late. She's going to Zoom from my office. I see that the AG's office is here. I think they're here on this case as well. The opposing party is pro se. Her name is Veronica Hernandez.
All right. I don't see her. I do not see anyone from the district clerk's office to see if she's trying to appear in person.
There also, I think, another party, Feliciano Rodriguez, who is the father of the child. He is also pro se, and I do not see him as well.
He will be coming with my client together to my office. They're on the same side, so they should be here shortly.
Okay.
All right. Well, I'll mark you conferring, and I will ask that you contact the district clerk's office and see if there's anyone who has shown up in person.
Yes, Your Honor, I will do that now. Thank you.
All right, thank you. San Miguel versus Peeler.
Louis Sutherland is here for San Miguel.
Mark Guthrie's here for Kiewit Mining Group. Good morning.
Good morning. All right. This is a motion for summary judgment on, it's cut off.
Your Honor, we moved some of the hearing settings around, and so I believe, and I hope I'm right, today we are hearing the motion to exclude Anthony Brown and Gordon Johnson, who are both Peeler witnesses, expert witnesses, and those motions were filed by the counter defendants.
That's correct, Your Honor.
That's correct.
Okay. All right. And do I have a link to those motions?
We sent it to Ms. Riley, but I can put it in chat if you'd like, Your Honor.
I did forward that to you this morning, Judge.
All
By
right.
email.
Okay. Yeah, I have not received anything since 5 o'clock yesterday. So apparently my server has some problems. So if you would send that to me, I'd appreciate it. Thank you. In chat, I mean. Okay. How long this morning or today?
My guess is about 3 hours for both altogether.
All right. I'll mark you conferring in that. And I need to let everyone know, I don't know how long you're expecting to take tomorrow, but you can see I had a follow-up surgery on my hand, looks kind of nasty. I have 2 follow-up appointments on that tomorrow afternoon, so I have to take off by about 2 o'clock. Hopefully that won't be an issue. Okay, in Wilson County, in re the marriage of Jesus Cuellar and Gabriela Cabrera.
That case was dropped, Judge. It's reset on request.
Okay, and then the add-on in re the estate of Gavlik.
I received an email this morning. They've requested that that case be passed. They have an agreement was reached.
Your Honor, if I may, I just wanted to apologize for not being there yesterday. We did reach an agreement. I was at a doctor's appointment and I thought we already had an agreement. So my apologies for not being in front of the court yesterday.
Okay, and Mr. Yost did say that you were very close to an agreement and that he expected that you just thought it was there and that's why you weren't there.
So I just wanted to apologize, Your Honor.
All right, that's fine. You're excused. Thank you.
Thank you.
I think that takes care of Wilson County. Judge, I'm going to sign off since that takes care of Wilson County.
It does. Okay.
Thank you.
All right. Let me look in chat. Okay, I've downloaded the motions. I'm going to leave my video running. I'll ask the Peeler attorneys to come back at, let's call it 25 after, or be ready by then, pending what happens in the family law case in Atascosa County. And have you all had an opportunity to hear anything back from the district clerk yet on whether there's someone there?
Yes, Your Honor, I called the district clerk and Norma at the courthouse. No one has shown up. Veronica Hernandez has not shown up. Judge, my client is not here, which is very unlike her. We cannot reach her, so we're trying. I don't know what's going on, but I'll have to report back.
Okay, well, I'll just mark you conferring and I'll keep my audio on, so if anything pops up, I'll be able
Okay.
to.
Your Honor, I have an update when you're ready.
Go ahead.
Judge, just a moment ago, Veronica Hernandez called my office, said she just woke up. She's headed to get Wi-Fi, so she's on her way.
Okay. And if you need a hearing, how long do you expect?
That's no more than an hour, I think. And we do have a CPS caseworker on standby. So we'll need a few minutes to get her on the line when it's time.
Okay. And did the pro se respondent give you any indication of what sort of time you're looking at?
No, Your Honor. She said she's headed to get Wi-Fi. That's all we know.
Okay. All right. Thank you. Okay, I'm back. Who is going to argue these motions for the movements?
Mark Guthrie for Kiewit Mining Group.
All right, are both sides ready? And this is on Anthony Brown.
Yeah, sorry, I was muted, Your Honor. Louis Sutherland for San Miguel.
All right, and are you taking the lead because I saw Mr. Schick filed this?
Yes, I will take the lead.
Okay. All right, go ahead.
Okay, I will start. We have two motions. I'll start with Mr. Brown, if that's all right with you, Your Honor.
That's the only one I've read, so yes.
Okay, all right, good. Anthony Brown is plaintiff's primary environmental expert. His training is as a hydrogeologist, and his primary opinions, they go to the issue of where there is contamination within the soil, the groundwater, and the surface water on the Pilar Ranch. And so that's the scope, the general scope of what he's trying to testify to in his opinions before the court. One of the, I guess the first objection to his testimony that I would like to address, Your Honor, is the fact that Mr. Brown did not address obvious alternative causes for what he alleges is contamination. And as a predicate to getting into that discussion, I would like to discuss a little bit of the case law. The primary opinion within the Texas courts regarding the level of examination by an expert to identify the causes of environmental contamination is the Mitchell Energy case. It's a case out of the Fort Worth Court of Appeals. That's 958 Southwest 2nd 430. In the Mitchell Energy case, the dispute had to do with environmental contamination to groundwater, allegedly caused by some gas wells that were drilled by Mitchell Energy. And the basic rule that court came out with was that an expert going to causation in an environmental contamination case must carefully consider and rule out potential alternative causes. And so I want to emphasize this point, I'd like to just look at a little bit of the language from the opinion. So Tony, if I can share my screen, Judge.
Yes, go ahead.
This is the Mitchell Energy opinion that I just referenced. If we go to PDF page 7, Tony, there's a little bit of highlighting here, just emphasizing for you, Judge, that what this case was about. The appellees were landowners in Wise County, and they alleged that the drilling of gas wells by Mitchell Energy had led to contamination of their water, and there was 12 Mitchell's gas wells in that vicinity. And so if we could just jump to PDF page 18, Tony. The court considered the objections to the admissibility of the plaintiff's expert evidence as to causation of that alleged contamination. And the contamination was primarily with a compound called hydrogen sulfide. The plaintiff's landowner expert was a man named Dr. Bassett. And the court's conclusion was that Dr. Bassett had not ruled out the possibility that hydrogen sulfide in the appellee's water could have come from a source other than the Mitchell gas wells. And so again, the language that we're focusing on here is he did not rule out the possibility. Now, let's go to PDF page 19, next page, and zero in on that highlighted text there. The court announced the rule that an expert who is trying to find the cause of something should carefully consider and rule out alternative causes. And then goes on to say that Dr. Bassett's failure to rule out other causes of the presence of hydrogen sulfide in the appellee's water renders his opinion little more than speculation. And of course, speculation is not evidence. And so just the takeaway from this case, Judge, is that it's not enough to do sort of the arm waving that we're going to see Mr. Brown did here in this case on alternative causes. You have to carefully consider and rule out those causes, and that is do a rigorous scientific analysis. It's more than arm waving. Another case that is cited in our brief that I'd like to spend a few minutes on is the Cooper v. Meritor case. This is a federal opinion, but it is based upon similar facts in that it's a alleged contamination to real property opinion where the issue was causation. You can see here on the first page that the claim was made that illegal disposal of chemicals in nearby industrial facility contaminated homes and property. So it's essentially, it's an environmental case. The issue was causation with respect to expert testimony. It's a recent opinion. It's from 2019. And in this case, the issue was what was the level of expert review that was necessary to render a reliable opinion that the industrial source was the sole source of the contamination. And what the court said is that if you're going to allege something as the sole cause, then you have to demonstrate that the other alternative causes are highly improbable. And those are the court's words, or highly improbable. And failure to do that kind of analysis renders your expert opinion essentially worthless. And so let's look at that language. Tony, if we could jump to, I think it's PDF page 17, zero in on that. Again, the court states a necessary ingredient of opinions on causation is the exclusion of alternative causes. A failure to test for obvious and significant alternative explanations renders an analysis essentially worthless. Let's jump on to page 19. The court summarizes as quoted above, an expert must adequately account for obvious alternative explanations. Necessarily, the adequacy of the accounting depends on the nature of the expert's opinion. However, to opine that something is the sole cause of an injury, the expert must eliminate obvious alternative explanations as highly improbable. And that's what Brown is saying here, is that this contamination was caused solely by San Miguel. Or alleged contamination. There's a couple of other cases that I would direct the court's attention to on this issue that are cited in our brief. There's the Lee Bolton v. Copper's opinion and NS Arden Golf Club. I'm not going to spend the court's time going through that language. Those cases are in accord with what we just went through, both with, both of those are federal opinions, but back up the general rule that's laid out in Mitchell Energy, which of course is a Texas opinion that says that experts in environmental cases testifying about causation have to carefully consider and rule out alternative causes. Now,
and I think the Peeler's attorney that agrees with your on the law, don't they? Aren't there a primary response simply that even if that is the law, that Mr. Brown's testimony does not violate those standards?
well, I'll leave it to the Peeler's attorney to address whether she agrees, but I will, at this point, I'm going to shift to whether or not Mr. Brown met those standards.
Okay.
I'm not certain, highly improbable is a very high bar. And, I'm not going to put words in Ms. Whittle's mouth that she believes that the bar is highly improbable, but that's what the cases say. So shifting to what Mr. Brown did and focusing on the obvious alternative causes, I'm going to discuss three. There are more than those, Judge, but sort of to streamline this presentation, I'm going to focus on three alternative causes and how Mr. Brown purported to address those causes in his expert testimony. The first, I'll address the saline groundwater impacts from the Peeler artesian well, which you've heard a little bit about before. Second, I'll discuss oil and gas activity. And then third, I'll address the natural saline conditions in the soil on the Peeler Ranch. So those are the three alternative causes that I'll focus on. And as we discussed, it's Mr. Brown's obligation to render causation testimony to carefully consider each of those alternative causes and rule them out as improbable. Now, looking at, starting with the saline groundwater from the free-flowing artesian well, Tony, if you can just pop up that picture real quick. This is a picture, Judge, from the plaintiff's expert, Lauren Ross's, one of her expert reports. This is the artesian well. It is, you know, as the court knows, an artesian well is a well that has sufficient pressure so that it naturally flows and continues to flow to the surface essentially all the time. And this well, the documents in the case show unequivocally, this well was drilled prior to 1900, probably in the 1880s. So it's over 120 years old, and it has been flowing water since it was drilled. Now we have some sampling from the 1970s, and the well in the 1970s was over 1% salt. That is 10,000 parts per million salt. With Lauren Ross repeated some of that testing in the last 2 or 3 years, and the concentration of salt is essentially the same. Now, the experts, it's difficult to get an accurate flow measurement on this well, but the testimony is essentially that, you know, this is 10 to 20 gallons per minute flowing 24 hours a day, 365 days a year for over 120 years on the Peeler Ranch, with concentrations of salt that exceed the concentration of salt that's allowed under the discharge permit for San Miguel discharge from Pond 7. And that's been going on for 120 years. Now, Mr. Brown acknowledged during his deposition that this well has been flowing for over 100 years. He acknowledged in his deposition that this well flowed into the drainage plane for La Perita Creek, which is at issue and is in the center of the area where the plaintiffs say that there is alleged contamination. But notwithstanding those admissions, he suggests that the well is not impacting the alleged contamination. Well, I want to show that is not the case. Why don't we pull up Exhibit 4, Tony? This is a map by the other expert that we'll talk about later this morning, Judge, by Gordon Johnson, also one of the Peeler's experts. It shows the drainage pathways and drainage planes around the power plant and the mine. If you look over to kind of center slightly left, you'll see it says Caballas Creek, and just to the left of that, that's where the power plant is. And then La Perita Creek is there pretty much right in the middle of the screen at this point in time, that kind of dog leg golf course looking pond down below it is Pond 7. And so La Perita Creek and the various drainage channels around that flow just north of Pond 7. So let's go to exhibit number 5, Tony. We'll zoom in on this. The upper left is the same map that we just looked at with the various drainage channels. The lower right figure there, Judge, is that is Anthony Brown's figure 47. That is where he identifies the areas of alleged contamination. And Tony, if we could just focus in for a minute on that lower, just zoom on just that lower picture there. You can see a pink line that kind of goes around that. if you can, it's too fuzzy to read, but if you go down to the legend, and we'll see more detailed pictures as the argument goes on, but Mr. Brown has labeled that pink line as the extent of all contamination. And so let's zoom back out so we can see both of them again, Tony. And so the yellow oval just roughly, very roughly, obviously, indicates, the general area where that pink all contamination is. And Brown has alleged that entire area has been contaminated by San Miguel. Okay, so let's go on let's pull up Exhibit 5.5. This is testimony by Mr. Brown on where that artesian well discharges into La Perita Creek. I asked him during his deposition, and this is your figure 49 where you show the surface water pathways. Do you recognize it? He said yes. And then we'll just take the location from Dr. Ross's report and place the artesian well. It's designated as the Peeler flowing well. Do you see that? Yes, I do. And that well, and this is the important part, that well is based upon your flow diagram is upstream of the La Perita Creek watershed before it goes to Pond 7, right? And then Mr. Brown's answer, it discharges to La Perita Creek slightly upstream of Pond 7. I believe the confluence is somewhere around well sampling point SW14 or just to the east of that. And so let's go to Exhibit 6 now, Tony, and zero in on that. And if you look at that smaller circle to the left, that's SW14, Judge. Tony, maybe we can zoom in on that and just show the judge. That right there is, you can just barely read the 14 to the right of the yellow circle. That little green dot, that's SW14. And as you can see, it's right in the middle of that pink line that Mr. Brown has indicated represents the extent of all contamination. Okay, let's zoom back out. And in addition to that, during his testimony that we just read, later on in his answers, Mr. Brown describes a number of other wells that are downstream of SW14, and he mentions SW17, 18, and 20. And in particular, let's focus in on that larger circle, which is where those three wells are. And in particular, you'll see SW18 is right there in the middle. It's perfectly in the middle of that pink area. The other two, 19 and 20, are on the edge, but they're either on the border or just inside the border of the area where Mr. Brown has indicated that's the extent of all contamination. And so his testimony, Judge, says that this area, well, his figure says this area is contaminated solely by San Miguel, but yet the artesian well, he acknowledges, discharges into this area with salt concentrations that are higher than the permitted limit than San Miguel can discharge from Pond 7. There's essentially no scientific analysis in Brown's report to rebut the contributions of the artesian well. It's nothing certainly approaches anything that would qualify as showing the artesian well's impacts are highly improbable. The Peelers raise a number of arguments about elevations and different things in their response to our motion to exclude, Judge, but you can look at these wells that he testified to is where the impacts occurred, and SW14 is right there at the main channel of the La Perita Creek. So that would be the lowest elevation in that general area. And, you know, and that's within the area that he says is the extent of all contamination.
And one more time, where is the artesian well on, say, this map here? Roughly?
If you look, see the dotted portion that is just to the left and above SW14?
Yes.
That right there, yeah, see that right there. It's where Tony has put the arrow. It's approximately around there, probably a little bit west of there. That's approximately where it is. And it flows downhill into the La Parida Creek watershed. And, you know, and the other thing that's worth pointing out here is that that you can see La Parida Creek goes on for several hundred feet, heading primarily east from SW14 and all of that until you get to about SW19 is within the area that Mr. Brown has says is the extent of all contamination. So that's the first obvious alternative source, Judge. The second obvious alternative source is oil and gas activities. Now, Brown has acknowledged that oil and gas spills can have some of the same environmental impacts with respect to boron, with respect to salt. I mean, as the court is probably aware, you know, produced water is very saline, and produced water also has a lot of boron in it. And so spills of produced water can produce environmental impacts that mimic what the peelers say what's caused by San Miguel. And if we could just go to Exhibit 7, Tony, and let's go to Brown testimony on page 45. And so I asked Mr. Brown, and you would agree with me that oil and gas operations produce waste that is generally referred to as produced water, correct? Yes, I'm very familiar with produced water. And then I asked Mr. Brown, and produced water has high electrical conductivity, high dissolved solids, correct? Yeah, it varies depending upon the oil field, but in general, I think it's reasonable to state that much of the produced water in active oil fields within the United States has high levels of dissolved salts, yes. So let's jump to page 60. And those metals that can be elevated based upon a brine spill from oil and gas activities would include boron, correct? Actually, yes. And as our evaluation, brine contamination related to oil and gas activities, particularly the brine ponds, boron is one of the constituents we consider. And it's important to note for the judge that boron is the key compound that Mr. Brown associates with impacts from the mine and from the power plant. It's the metal that he focuses on. And so the fact that boron is also present in produced water makes it especially important to evaluate and rule out as improbable potential impacts from oil and gas activities. Because as we know in Texas, spills of produced water occur all the time. And so let's go to exhibit number 8, Tony, which is a map. This is a map that was created by Mr. Brown. I actually put the blue outlines on it and arrows in the text box there, but that is roughly just sort of roughly approximates the areas that Mr. Brown indicates have been impacted by the operations of the power plant and the mine. And if you look, all those dots are historical oil or gas wells. All of the yellow are historical or existing pipelines. There's well over 30 wells, and there's literally dozens of miles of pipelines that run throughout the area of alleged contamination, as well as areas that are up gradient and nearby to the areas of alleged contamination. And, Brown also admitted during his testimony, and the citation is in the brief, that, while he looked at reported spills, most of these wells were drilled prior to, modern environmental law. So there's, nobody reported spills from oil and gas activities prior to 1980. And so, he can't rule out impacts based upon reports to the Railroad Commission for wells that predate that time period, because simply there wouldn't be a record at the Railroad Commission of those kinds of spills. There are, however, ways to do an analysis to separate impacts from the mine and the power plant from oil and gas activities. But those techniques are scientific techniques where you look at the nature and the character of the environmental data and you make assessments as to whether or not that data actually looks like it came from an oil and gas well, or whether it came from some other source, perhaps the mine or perhaps the power plant. Now, those techniques are well established in the scientific literature. Indeed, Mr. Brown testified that he had used several of them as part of investigations in other cases. Those techniques include things like trend analysis. Trend analysis is simply looking at a particular source and seeing, and typically the highest concentrations are close to the source. And so you look to see if you get a trend with distance or with depth that indicates that it came from that particular source. That's one technique. Another technique is ratio analysis. And spills of brine don't just have boron in them. They have boron, they have selenium, they have a lot of other different kinds of compounds that we can easily measure. You can look at the ratios of those compounds, like boron to selenium. If the boron is 100 parts per million in the brine and selenium is 50 parts per million in the brine, once you get 100 feet away from the spill, you're probably not going to have 100 ppm and 50 ppm anymore. It's going to get diluted. But what is still intact is the ratio. That 1-to-2 ratio of boron to selenium is still there. And so you can do ratio analysis to see where it came from.
When I was county attorney, we actually ordered a number of basically sealed forensic sample kits to give to the sheriff's department, because for a few months we had 1 or 2 bandit contractors who were saltwater disposal trucks, and they would pick up a load and then they just go dump it in the drainage ditch on a county road somewhere. And we put out the information that we were doing this, and what we were threatening the folks with was that we're going to have them take samples and get a profile of the water that was dumped and then match it up to the well it came from. Now, I'm not sure that we could have actually matched it up to the well it came from and identified the operator, but after we put that story out and it got out, we stopped having that problem.
And likely, Judge, these same techniques that I'm describing, that your environmental forensic people would have done the same thing, because once it's in the ditch, it gets diluted, right? So the concentrations are not the same, but everything gets diluted the same, right? And so those ratios are still intact. And another more sophisticated statistical technique that's somewhat like a ratio analysis is called a principal component analysis. The power of a principal component analysis is ratios is just 2 chemicals. Principal component analysis, you can do like 5 or 6 chemicals to look to see if you have that signature, that you were just describing in the compounds. I mean, in the testing. And that kind of testing is accepted. That kind of testing Mr. Brown has done before, but he didn't do that here. And he could have done it here. And to show that oil and gas impacts are improbable, to do a careful analysis and rule out oil and gas as an alternative, he should have, and he didn't. And without doing that, his opinion is not reliable. And, Mr. Brown just saying, well, I looked at it, none of them were close, and I didn't see any reports from any of these spills. That's not good enough. That's not good enough under Mitchell Energy. The third thing.
And Mr. Solomon, let's interrupt just for a moment. Let me ask you to stop sharing your screen. Veronica Hernandez, who's here on the family law case, is signing in, and I want to try and get her into a breakout room once she gets fully connected.
Sure.
All right, Ms. Hernandez, this is Judge Wilson. I'm asking you to start your video.
No. Okay, fine. Thank you.
Okay, excellent. All right, and Ms. Hernandez, you have a case involving a child here in court this morning, is that correct? All right, Ms. Hernandez, can you hear me? All right, Ms. Hernandez, can you hear me?
Okay.
All right, can you hear me?
Yes, sir.
Okay. You have a case this morning involving Micah Rodriguez?
Micah?
Micah Rodriguez?
Yes, sir.
Okay. All right, and are you ready to proceed on that?
I don't have a lawyer. Is there a way I could reschedule it until I have enough for a lawyer?
Well, ma'am, I don't know how long this case has been set or anything else. I can tell you that I have to have a lot more information. All right, let me finish. What I am going to do right now is I'm going to put you and the attorney from the AG's office, Ms. Reed and Ms. Harkins, and the other party into what's called a breakout room. And a breakout room is like a separate electronic room you'll go to. It's not being recorded. No one else is watching it. And y'all can, all of you can discuss the matter there. If you're able to come to a resolution, whether it's to make a decision this morning or to put it off to another day, that's fine. If you're not, then I will hear either your motion for more time or hear the case on the merits later this morning. All right, so again, I'm going to put you into give you an invitation to a breakout room in just a moment. And I'm going to ask you to go into the breakout room and discuss that with the attorneys and the other party.
Judge, you can leave my client out. They're here in my office, so I can run over. I think it'd be best that they not be included.
Okay.
Thank you.
All right, so I just Reed, Harkins, Hernandez. And I just hit the open button. So you should have received on whatever electronic device you're on an invitation to a breakout room.
Yeah. Join.
Okay, yes, join.
Thank you.
All right. Go ahead, sir.
Sorry, I had on mute. I was about to swap topics. The third area or alternative source that I'd like to address on this point is natural saline conditions that are ubiquitous on the Peeler Ranch. And I'd like to start the discussion about the natural salinity with a question, really. Why didn't Mr. Brown use the background analysis of salt constituents the same as he did for metals? For metals, the peelers drilled 30 borings. They collected samples from 3 or 4 depth horizons. They had those samples analyzed. They spent a lot of money developing what they describe as the background conditions of the Peeler Ranch. And it's that data, and particularly the boron data from those wells, that Mr. Brown uses to define what the natural condition of the ranch is with respect to metals. Why didn't he do that with the salt constituents? They hired an expert, Lauren Ross, who they purport is an expert in her field. Her specialty is to analyze environmental data to identify environmental contamination and to identify and describe what background concentrations are. She apparently taught classes at UT in that particular subject matter. She calculated background numbers for the salt constituents at issue. She calculated background numbers for calcium. She calculated background numbers for sodium. She calculated background numbers for chloride. She calculated background numbers for sulfate. Why didn't they use the background numbers that Dr. Ross calculated to assess the natural background conditions for salt? the Peelers have acknowledged in their pleadings in this case that those compounds or elements, they're really cations and anions, are indicative of salt and the salt contamination that they complain about. They had the data. Let's look at the data. Tony, why don't we pull up Exhibit 9? This is Dr. Ross's table of her calculations with respect to background concentrations. And it's the non-probabilistic 95% upper bound is what it is, but it's essentially what the parties have been describing as the Peeler's background calculations. You'll see that they collected data on calcium, they collected data on chloride, and that bottom row down there is Dr. Ross's calculation of the upper bound of background. And you'll see that the numbers for cadmium and chloride are very, very high. 68,000 parts per million for cadmium, close to 3,500 parts per million for chloride. That's 69,000. So let's scroll over to that last row there, or column, Tony. So we've got numbers for magnesium, another compound, that would be a cation associated with salt. They had data for magnesium. Again, the number is very high. Let's go to page 2. Zero in on that data. It had numbers for potassium, had numbers for sodium. I mean, we've been talking a lot about sodium chloride. So we've got both sodium data, which is the cation, and we've got chloride data, which is the anion. Both of those numbers are very high. We've got data for sulfate. We've been talking about sodium sulfates and calcium sulfates as indications of salt. Again, that number is very high. What that indicates, Judge, is that there are very high levels of these salt constituents that are naturally present, because this is the data from the Peeler's background sample locations from 30 borings that they took over multiple depths. There's no discussion of this data, this background data that indicates salt anywhere in Mr. Brown's report or in his rebuttal report. It's also worth noting, we can put that down, Tony. It's also worth noting, Judge, that these cation and anions that we just went through, where the Peelers collected data on, those are the exact same parameters that the Texas Commission on Environmental Quality regulates when they're regulating salt impacts under the Texas Risk Reduction Program that we were talking about as part of our state action level argument that took place before Christmas. If you recall, we went through a long discussion about how you can calculate protective concentration limits, or PCLs, for ecological impacts from salt, and that the TCEQ had identified procedures in order to do that. And these cation and anions that we just went through are the exact ones that the state of Texas regulates as state action levels under those circumstances. And the type of data that the Peelers already possessed from their 30 samples from their what they identified as background locations is some of the preliminary data that they need in order to do that kind of assessment. So they had part of the data already. So why didn't they use it? Well, the reason why they didn't use it, Judge, is because all of the numbers are so high that if they looked at the upper range of background and they applied the upper range of background to the areas that they allege are contaminated, essentially all of the areas of contamination go away with the exception of a few isolated areas, particularly an area just north of the power plant, which has already been remediated by San Miguel. why didn't Mr. Brown look at the TCEQ PCLs? Why didn't he look at the PCLs and address those PCLs in his report? Well, let's look at Mr. Brown's testimony. Let's pull up Exhibit 7 and go to page 63, Tony. I asked Mr. Brown, and are you familiar with the Texas Risk Reduction Program? His answer, just vaguely. I would not say I'm familiar in any detail, no. So the Peelers hired an expert who had no understanding of the fundamental process in the state of Texas to set state action levels. He had no understanding of the Texas Risk Reduction Program. He had no understanding of the process that was used to calculate ecological protective concentration limits, which would be the state action level at issue in this case. And as I stated before, there's no discussion of these anions and cations where they had the data for in Mr. Brown's report. He certainly did not meet his burden to carefully consider the influence of natural salinity, and he certainly did not meet his burden to rule natural salinity out as a cause for some of the salinity that was measured within the alleged contaminated area. Shifting topics, Brown's designation of the geographic areas of the alleged contamination are also unreliable. So I'm shifting away from alternative causes and just looking at the areas that he designated as allegedly contaminated. Now, we made this point in our brief, and in our brief, we argued that Mr. Brown's reliance on the Canadian electrical conductivity and sodium absorption ratio standards that were suggested by another peeler expert, Gordon Brown, was unreliable. So the essence of our argument was Gordon Johnson picked these Canadian standards, Brown relied on them, and Brown's reliance on Johnson and his Canadian standards is unreliable because this isn't Canada, it's Texas. The peeler's response to that was that Brown didn't rely on that. And they said that he didn't rely on the Canadian electrical conductivity and sodium absorption ratio standards. Well, I'd like to show you what he told me in his deposition. So, Tony, if we can pull up Exhibit 7 and go to page 144. And so I asked him, it's your testimony that you did not use a threshold of 200 millisiemens per meter as the criteria for the exceedance of electrical conductivity. That's your testimony. What Mr. Brown stated was, for electrical conductivity, the exceedance that we depicted, the extent was based upon the Alberta Tier 1 criteria. The Alberta Tier 1 criteria are the Canadian standards that were identified by Mr. Johnson. So that's not what he told me in his deposition.
And Canadian standards for what?
They're Canadian standards. The first one is for electrical conductivity. And the second one is for sodium absorption ratio. Neither one of those is a compound, an element, but they have been used, I think it's fair to say, by both sides as surrogates for the presence of salt. Because, you know, when salt is present in soil, it makes the soil more conductive. And so that's one indication that there's salt present. The sodium absorption ratio is a measurement of how much, it really indicates how much sodium is present versus calcium and magnesium. But it's an indication that can be used for the presence of sodium chloride in particular.
All right, and I can understand how different soil types, different moisture levels might make a difference. I mean, West Texas, how where you have some of the Chihuahuan desert might be different than the piney woods in East Texas, but just just because you have two different types of two different places, I don't know if that would necessarily make a difference. I mean, the Chihuahuan Desert in West Texas might be exactly like the African desert, and I don't think it would be valuable to say, well, this is a Libyan standard that you're using if you're talking about two different kinds of the same sort of soil conditions. So, or type of.
I think you're obviously correct, Judge, but I think the key thing that you said was that you have similar conditions. And Atascosa County, particularly southern Atascosa County, geologically was an inland sea. Right. And there was lots of precipitation of salt that occurred when those seas dried up. And that's why the soils in the Peeler Ranch are very saline, is because of that geological history. That's not true with Alberta. Alberta, Canada was not an inland sea. And at a minimum, I'm sorry?
Is that in the record? I mean, I know it's pretty far inland, but is that in the record?
Well,
as far as...
It's not, no, there's no testimony, but I think the court can take judicial notice that Alberta is part of the, a large portion of the Alberta is in the Rocky Mountains. And at a minimum, Judge, I would suggest that if an expert wants to apply a standard that is from a location that is probably at least 2,000 miles away, there should be a scientific development to show exactly what you just said. And that is that the geological conditions are comparable, because we know that the natural salinity of soils varies substantially. You wouldn't use, to give another example, you wouldn't use the salinity and the saline data for samples that are adjacent to Matagorda Bay, where you had, a saline water body right next to it, to assess the soils in Marshall, Texas, up in the Piney Woods, because they're not the same. And if you're going to say they're the same as an expert, you have to show that.
All right.
So moving on, in their brief, the Peelers say that Mr. Brown did not rely on this saline, the electrical conductivity and the SIR data to describe his areas of alleged contamination. So on page 16 of their brief, they state, in fact, Mr. Brown has been absolutely clear that he relied upon the elevated concentration of metals, not soil conductivity, to identify the extent of contamination. And then at page 20, the Peelers state, but when it came time to make conclusions about the scope of contamination, Mr. Brown did not rely on electrical conductivity or SIR data. Instead, he based his conclusions upon the presence of elevated levels of individual constituents of concern, boron, rather than EC and SIR. Now, we've already gone through, he didn't base any of his conclusions on individual constituents of concern associated with salt. There's no discussion of chloride, there's no discussion of sodium data and background data for that. Okay, so let's take the Peelers' comments at their word. But if that's the case, then Mr. Brown has no admissible opinions with respect to salt contamination. Now, they've said this case, they've talked in other contexts about how this case is all about salt. But if he's basing his conclusions based upon metals, and he didn't even look at the individual constituents according to salt, then he has no opinions with respect to salt contamination, at least none that are admissible. No opinions as to contamination based upon electrical conductivity. No opinions based upon alleged contamination with respect to sodium absorption ratio. And the practical implications of making that determination is that his opinion should be limited to where he has alleged that there's contamination from boron, because that's the only metal element that he references in his deposition testimony that he says he can draw reliable conclusions about where the area of contamination is. It's limited. It's just boron. Now, if we go back to, let's go ahead and pull up exhibit number 10, Tony. This is Brown's figure 47, unannotated as it appears in his report. And as you recall, there's the pink line, which is his area extent of all contamination. So let's just go down to the legend there, Tony, so that we can show the judge the two lines. So you can see the pink is extent of all contamination, and then the color doesn't show up great, but the brown line is the extent of boron contamination. All right, so let's go back up to the figure and zero in on the pink line. So this is his extent of all contamination. No, so his extent of all contamination, notwithstanding the Peeler's argument that he was only relying on boron, is much larger than his boron contamination line. You can see that the brown lines are inside the pink line. Let's go to exhibit number 11. So the brown lines are a little hard to pick out. And so what I did, Judge, is I just traced the brown line and colored it yellow so you can see it. If Mr. Brown is only saying boron is an indication of alleged contamination, then his opinion is limited to this yellow, because that's where his boron line is. And his pink line, which up until this motion was the extent of all contamination, none of that comes in. And this figure that shows that pink line would be highly prejudicial if indeed he's saying that electrical conductivity and sodium absorption ratio are not indications of contamination. Now, and if you'll just zero in on SW18, it's right there kind of towards the top. Yeah, there you go. He's indicated with the SAR and SC, that's SC is specific conductivity, which is equivalent to or very similar to electrical conductivity or specific conductance. So it's essentially the same thing as electrical conductivity, and SAR, or sodium absorption ratio. Those are the only things that are showing up as potential sources of contamination in SW18, to the one just below it, SW20, SW22. And so if we're throwing all that stuff out, then none of this stuff, MW24 over to the left, same thing. None of this stuff is contaminated, even according to Mr. Brown. And he shouldn't be allowed to testify that it is. Now, as discussed above, Brown ignored the data that relevant cation and anions that are associated with salt. He ignored the analysis of Lauren Ross with respect to the salt cations and anions. He ignored the analysis of potential impacts from salt using the TCEQ TERP PCL process. And you know, he references some visual observations of contamination within his report, but there's no documentation of that. That's just ipse dixit. That's just because I say so stuff. If we go to Exhibit 7, let's go to page 19 of his deposition. I think it's a page 19. There you go. I asked him during his deposition, I reviewed your original report as well as your rebuttal report, and I did not see anything in those reports that were reported to delineate geographic areas that meet these visual observation criteria that you've described. Did I get that in the report? Mr. Brown responded, I think you are correct. I don't believe there's a discussion in my report of the visual observations made when visiting the Peeler Ranch. So his visual observations of, one, there's no indication he's qualified to, by visually observing property, make determinations as to whether it's environmentally contaminated. But two, even if he was, that's not reliable expert testimony where there's essentially no paperwork, there's no maps, there's no field notes, there's no descriptions. We don't know where within his pink line he's made conclusions about contamination based upon some sort of visual observation. We're left to guess. That's not reliable testimony, Your Honor. Even with respect to the metals, Your Honor, Mr. Brown's testimony is not reliable. For the metals, boron and others, TCEQ actually publishes PCLs for human health impacts. He didn't reference those at all. He didn't indicate where he's indicated there was contamination above a state action level based upon those published values by TCEQ. And he didn't even address the injury that the peelers allege here. That is the peeler's ability to use the property as a cattle ranch. That's not part of his report at all. We could go to his deposition testimony, Exhibit 7. Let's go to page 91.
Am I on the right page?
Hello?
Am I on the right page?
All right, Ms. Hernandez, we're still in another hearing. I'm going to ask you to keep your computer muted. I'm going to mute it right now. Go ahead, sir.
I'm real close to being done, Your Honor. And so here's the testimony from Mr. Brown on what he looked at, and starting at line 7. And if I understood your testimony correctly from earlier this morning, you had many opinions with respect to whether the condition of the soil or the groundwater impairs the peeler's ability to use the property as a cattle ranch. And you said, that is not an opinion I've been asked to offer. I think I read that poorly, but essentially what Mr. Brown acknowledged, that he was not providing any testimony that any of the property conditions that he was describing in any way impair the peeler's ability to use the property as a cattle ranch. The last topic that I want to address before I finish, Your Honor, is there are a number of areas that if you look at Mr. Brown's figure 47, which we've looked at several times today, where he says that it's possibly contaminated. And if we could just go back to figure 47, that's Exhibit 12. So I've annotated figure 47 here for you, but there's 3 areas where in this figure, Mr. Brown has indicated that it's possibly contaminated. He has no sampling and he has no scientific data to indicate that these areas are contaminated. On page 3 of the peeler's response with respect to these areas, they acknowledge that contamination, and I'm quoting here, contamination might be present, but could not be confirmed. That kind of speculation is not admissible scientific testimony, Your Honor. And this figure is highly prejudicial because it suggests that contamination is present when there is no reliable scientific evidence that suggests that it actually is. And so we would add the additional objection that this is that this figure should be struck. And so for those reasons, Your Honor, we would move that Mr. Brown's expert testimony be excluded.
Okay. I don't see Mr. Guerrero. So Ms. Whittle, I'm going to take a report from the civil case, and then we'll take a break for a few minutes, and we'll come back with the response. All right. What is going on, Ms. Harkins?
Yes, Your Honor, we conferred. We were not able to reach an agreement. Ms. Hernandez would like to ask for more time to hire an attorney. So, and we're objecting. So we need a brief hearing on that. And then if we do proceed today, I think an hour or less.
Okay. And all right. So Ms. Hernandez, are you able to sit down so we can speak? I'm going to unmute your computer or ask you to do it.
Yeah.
Okay. All right. So Ms. Harkins, what do we have to hear this morning?
Judge, so we're set. My client had filed an intervention. This SAPSR has been filed since 2016, and my client intervened in April of last year. She's had the child. You'll hear testimony. So she's asking for primary conservatorship. And the issue is that Ms. Hernandez had an attorney who withdrew in November, and then we reset to today. So that's why I cannot agree to resetting again and why we're objecting.
Okay, and Ms. Hernandez, are you in agreement with the timeline that Ms. Harkins has just laid out?
Is there a way you can reschedule it until I can pay for a lawyer?
Okay, I just asked if you heard what Ms. Harkins had to say about the timeline of how we got here today?
Yeah, about 10 o'clock.
No, I'm asking you, Ms. Harkins just stated to me that her client intervened in this case last year, that you were represented by an attorney until November, and that your attorney withdrew in November, and that the case was previously reset for you to have an opportunity to hire an attorney.
Judge, just so I can explain, she did not appear in November.
Okay, okay. All right. Well, let me ask you, when was this setting made?
Judge, we set this.
Remember my lawyer resigned?
Judge, we set this November 24th.
Okay.
Hit me with a surprise.
Okay, Ms. Hernandez, I need to ask you, why are you walking around all the time?
No.
All right, please sit in one place. Or stand, I don't care. All right, can you hear me, Ms. Hernandez?
Private spot. Go outside.
Victoria Hernandez, can you hear me?
I'm looking for a spot to sit down. Better?
All right, ma'am. Do you agree that this case was set for trial today back in November?
Back in November. I don't know, the court date was set today, and I had my child, and then 11 months ago.
Okay, ma'am. Okay. What actions, since your last attorney withdrew, what actions have you taken to hire a new attorney?
I've been trying. They hit me with a good amount of time to where I can't even afford an attorney.
Okay. We will hear this at 1 p.m. We're going to take a recess until 10:45. I'm going to finish up the Peeler matter that we haven't heard on hearing today, and you need to be available at 1 p.m. on Zoom, and we will have I can't hear you. I can't hear you.
Is there a way you can no, you sound like Lucy. Is there a way you can reschedule to where I could reschedule to freaking pay for a lawyer? Or do I have to?
We're going to hear this at 1 o'clock this afternoon.
If something happens.
We're going to hear this at 1 o'clock this afternoon, okay?
And Judge, the Zoom room is available at the court annex if she wants to come there for a little
All right,
bit.
and
Yeah.
Ms. Hernandez, where are you? What city are you in?
Jordan.
Okay, if you will, I'm gonna take a break for a moment. If you will talk to Ms. Riley, she will tell you where the courthouse annex is, and they have a room there with a computer so that you can have a place to sit down and you're not trying to use your telephone, okay? And we'll hear this at 1 o'clock.
Judge, may I be excused until then?
Yes,
You ready?
excused until 1 o'clock, and I will be back at 10:45 and we will start.
Thank you, Your Honor.
And just to confirm, it will be the same meeting ID number and passcode to get in at 1 o'clock.
Yes, or you can just leave it running.
Thank you, Your Honor.
Oh, Cnty, what the heck? I need to look up this stuff.
Veronica, if you can hear me, my name's Lori Riley. I'm with the court coordinator's office. You can come to the court annex in Jordanton at 1405 Campbell Avenue. That's by the courthouse. And there's a Zoom room. You can come in there and check in with the bailiff at the front, and we can have you set up in there, which might be easier to be in a secure spot and be on the Zoom hearing if you'd like at 1 o'clock. You'll have to wear a mask in there. Okay? Did you get the address? I can't understand you. I can't understand you.
What's the location again?
1405 Campbell Avenue. It's the new building across the street from the courthouse, the Atascosa County Courthouse. Okay? Did you catch that?
All right, I'm back. All right, go ahead, Ms. Whittle.
Your Honor, Mark Guthrie, if I may.
Oh, yes, sir. I'm sorry. There's co-movements. Go ahead.
Thank you. I'll be real brief. First of all, Kiewit Mining Group adopts Mr. Sutherland's arguments and joins obviously in the motion. I wanted to make a few more points. In terms of Mr. Brown's background, he is a Canadian trained hydrologist. He now lives in Southern California. He is not the holder of any professional licenses or certifications, such as a professional engineering designation, particularly in Texas. He's not a professional engineer, and therefore he is not constrained by the code of conduct that licensed Texas engineers are required to follow. And so that's a concern just about his qualifications to testify as he has in this case. His only observations about Kiewit Mining Group's activities were on the day he visited the Peeler Ranch and he watched dump trucks on haul roads. I'll get into this more in the supplemental motion to exclude Johnson and Brown, but his observations about Kiewit Mining Group are very, very limited. Let me move to, I'm going to see if I can share my screen.
Go ahead.
And this goes back to Mr. Sutherland's discussion about the failure to rule out alternative sources. This is, I hope you can see, a part of Mr. Brown's deposition transcript. And that appears on the PDF page 126 of the joint motion. And he's testifying about figure 47 that I think Mr. Sutherland showed you a few minutes ago, the delineation of the areas where he believed there is soil contamination. Mr. Sutherland's asking him, beginning at page 43, line 9, about alternative sources. And down at line 20, he asks him, did you, as part of your evaluation of that analytical data, consider whether or not the particular constituents of concern had the potential to occur from other sources? His answer was, we did during our evaluation try to identify if the contaminations that was observed, and particularly the magnitude and extent of the contamination, might be an indication of another source contributing to contamination. Then Mr. Sutherland asked him, and did you consider that alternative source analysis in your report? Or did you discuss that alternative source analysis in your report? The answer was not that I can recall. We could not identify any alternative source. I wanted to call that to the court's attention. I think it's significant. In his timely filed reports, he did not discuss any process of ruling out alternative sources, and his opinions on that are essentially ipsy dixit. There's no process, there's no scientific evaluation, at least that he documented in his timely filed reports. Now, that's significant because the peelers have come back and attempted to add a supplemental declaration by Mr. Brown, his second untimely one in this case, to their response to this joint motion. And in it, I think he tries to state that he considered and ruled out alternative sources. He also adds some new opinions that I'll get into more later in connection with the supplemental motions to exclude Johnson and Brown. But Kiewit Mining Group objects to the supplemental designation that was attached to the peeler's response to the joint motion to exclude as untimely and prejudicial, as well as the earlier supplemental designation that we discussed in connection with the hearing on the state action level motion for summary judgment in December. And we adopt the arguments in the written objection that we filed in connection with that hearing as to Mr. Brown's supplemental designation. The fact of the matter is, at best, he did a windshield drive-by about alternative sources, and I think that's being charitable. And I think that is fatal to his opinions based on the case law that Mr. Sutherland pointed out. All right, I'm gonna stop sharing my screen. Okay, is that off now?
Yes, sir.
I'm sorry, I don't have an assistant with me to run the presentation. I think that's all I have for the joint motion. I'll present the rest in connection with the supplemental motion that was filed on behalf of Kiewit Mining Group. Thank you, Your Honor.
Your Honor, SEC has joined in this motion as well, but doesn't have any further argument.
All right. This is for real, Ms. Whittle.
Okay, I was planning on responding to both the motion that was filed by all of the parties and the supplemental motion by Kiewit at the same time. Does the court want us breaking that up? In the past, we've done it all at once.
Okay, I just read the first motion, so let me do that. I did not even know until we got into this what the other motions to exclude were. So give me a few.
Give
me a few minutes to look at that in the response, and then I'll let the other attorneys back up if they want to. Ooh. All right, I keep muting myself and then unmuting. I'm unmuted now. All right. Let me ask the movement's attorneys, do you think it would be better for me to read your supplemental motions, or would you rather keep them split up?
Your Honor, the only complication here is that our supplemental motion, the Kiewit Mining Group supplemental motion, is Johnson and Brown together. So I can try to split up the supplemental motions for Johnson and Brown. We can do the supplemental motion for Brown and then come back to the supplemental motion for Johnson later, if that's what everybody wants to do.
Okay, and this is Kiewit's, KMG's motion, so Mr. Sutherland, you don't need to argue that.
That's correct.
All right, give me a moment to read this and the response, and then I'll let Mr. Guthrie do that, and we can hear them jointly. All right, was there a supplemental or a Peeler response to the supplemental motions to exclude?
Sorry, Your Honor, I'm restarting my video. We responded to their supplemental motions within our main responses. So it was a consolidated response
Okay,
to both for Anthony Brown and to both for Gordon Johnson.
okay. Excellent. All right, then you can go ahead, ma'am. Or go ahead, Mr. Guthrie, on your supplemental motion on Brown only.
Thank you, Your Honor. Kiewit Mining Group moves to exclude opinions and conclusions of Brown as well as Johnson under Rules 702 and 403 that relate to the fact of any alleged contamination or pollution on the Peeler Ranch to the extent of the claims against Kiewit Mining Group, and regarding causation by Kiewit Mining Group of any alleged contamination on the Peeler Ranch. If the court will recall, we made a similar motion that the court granted as to the geophysical expert, electroconductivity expert, Bowman. And this motion to exclude includes the opinions and conclusions that whether or not contained in their timely reports or in their depositions, on the basis that the opinions and conclusions are neither relevant to Kiewit Mining Group nor reliable as to Kiewit Mining Group, and it would unduly prejudice Kiewit Mining Group for such general and non-specific opinions about contamination or the causation thereof to be admitted against Kiewit Mining Group. Kiewit Mining Group also moves for exclusion of the wholly new opinions contained in Brown's two additional untimely declarations that the Peelers have submitted in response to motions, including this motion to exclude, on the grounds they are untimely and prejudicial and good cause does not exist to admit them. Some of these new opinions are more specific to Kiewit Mining Group than are contained in the Brown reports, of which there are, I believe, 3, but they're also not relevant or reliable. As the court will recall, Kiewit Mining Group performed mining services at the San Miguel lignite mine under a contract with San Miguel that ran from January 2011 to July 2020. And it was San Miguel's third such mining contractor. Kiewit Mining Group's not a party to any lease agreements between San Miguel and the Peelers regarding the Peelers' land. Based on the court's ruling on the economic loss rule motion for partial summary judgment, the Peelers can't maintain tort claims against Kiewit Mining Group as well as San Miguel or Steck regarding property that is subject to the applicable buffer zone and mining leases on the Peeler Ranch. And those claims were dismissed. As a result of that ruling, the Peelers are limited to their contract claims against the parties other than Kiewit Mining Group regarding the lease property, and their tort and statutory tort claims against the parties related to property outside of the lease property. And so therefore, the only remaining claims the Peelers have against Kiewit Mining Group are those tort and statutory tort claims that arise from or are based on alleged contamination of property outside of the buffer zone and the mining leases. Brown, the hydrologist, has opined in reports and depositions in this case that portions of the Peeler Ranch, both inside and outside of the leased premises, are contaminated or polluted by the power plant and mine, and that this contamination, alleged contamination, requires remediation. He also attempts to blame Kiewit Mining Group somewhat for this alleged contamination, but as was pointed out in the joint motion, he does not base his opinions on contamination or pollution on any violations or exceedances of any state environmental regulatory action level for any contaminant. Nevertheless, Brown, as well as Johnson and other peeler experts, make many of these inflammatory opinions and conclusions about contamination or pollution in a blanket fashion related to the operation of the plant and mine, without differentiating between Kiewit Mining Group and other parties or the prior mine operators, of which there were two. And these opinions delivered in blanket fashion would be highly prejudicial to Kiewit Mining Group if the court permits them at all, since they're based on an incorrect legal standard. So in general, Kiewit Mining Group's objection to relevance is based on the low subjective standard they apply to reach their conclusions about contamination, which is the exceedance of a calculated background level instead of a state environmental action level. And secondly, the failure to identify, based on any scientific analysis, any contamination caused by Kiewit Mining Group that proximately caused damages to the peelers. In general, our objections to reliability, insofar as Brown is concerned, is based on Brown's failure to conduct scientific testing or to rely on scientifically conducted testing by others regarding the causation of contamination generally, the causation of contamination specifically tied to KMG's activities. As was pointed out in the joint motion, Brown and those on which he relies did no scientific testing to rule out alternative causes, and did no scientific testing to demonstrate the connection between these posited pathways of contamination or Kiewit Mining Group's activities and actual contamination. They don't connect the dots with actual testing that shows any causal nexus between KMG's activities and the alleged contamination. They also didn't do any scientific test to tie actual property damages complained of, that is the alleged failure to be able to use the property as a cattle ranch, to contamination such as alleged groundwater contamination as they define it. And part of that relates to opinions about contamination of shallow groundwater aquifers that are not usable anyway. Never have been, never will be. The Robinson case, as the court will recall, that involved a claim that contaminated fungicide to damaged pecan trees requires that an expert conduct testing to rule out other possible causes. And as in Robinson, Brown assumes that their market basket of industrial uses that they've identified that make up these pathways, or supposed pathways, are responsible for all damages the peelers claim on their property. As was also pointed out in the joint motion, nobody conducted any scientific testing to delimit the alleged area of groundwater contamination, which again relates to units in aquifers that are not usable. Never have been, never will be, because of their high salinity. As a matter of law, this scientifically unreliable evidence is of no assistance to the trier of fact and is inadmissible. And I will also rely on the cases Mr. Sutherland showed you in connection with the joint motion. Regarding the issue of causation, as the court well knows, the elements and components of proximate cause are cause and fact and foreseeability. Texas Supreme Court says these elements cannot be established by mere conjecture, guess, or speculation. That's the McClure versus Allied Stores case, which you find at 608 Southwest 2nd, 901, at page 903, in the Farley versus Cattle case that you can find at 529 Southwest 2nd, 751, at page 755, both Texas Supreme Court cases from 1975 and 1980. And the element of cause and fact or causation in fact requires that the defendant's conduct must be a substantial factor in bringing about the plaintiff's damages. And the Union Pump versus Albritton case at 898 Southwest 2nd at page 775, the Prudential Insurance versus Jefferson Associates case, 896 Southwest 2nd at page 161, and the Lear-Siegler Inc. versus Perez case at 819 Southwest 2nd at page 472 stand for these propositions. I want to go through a summary next of the opinions in Brown's original report, supplemental report, that I copied from Brown's supplemental report, which restates his original opinion summary from his original report. And if the court will bear with me, I will share my screen.
Yes, it's sharing. It used to let you know when you were sharing. I have to tell you, it's rather small. I can't really read it much.
The Anthony Brown report summary.
Yes, sir. If you would zoom in on your Word.
Let me try to do that.
Your view, that would help.
Okay.
You can do page width if you'd like.
Okay, let's try that. Does that help?
Yes.
Okay. All right. This is just something, again, I copied out of the Anthony Brown's timely filed reports. The supplemental report, again, just duplicates what was in his original, at least in this summary. His opinions have releases at the power plant and mine contaminated the ranch? Answer, yes. Did poor operational practices cause releases at the plant and mine and violate regulatory standards? Yes. Let's stop here for a minute. He's a hydrologist. How is it that he's qualified to opine about operational practices at a power plant or at a lignite mine? The answer is he's not. His third opinions, what are the sources of contaminants of concern that have impacted the Peeler Ranch? Coal ash pile at the power plant, yard drainage detention pond at the power plant, coal ash ponds A and B at the power plant, equalization pond at the power plant, coal ash landfills areas. And this refers to areas that the prior mining contractors filled in as part of the reclamation process using coal ash. KMG had nothing to do with mining or reclamation on the Peeler Ranch. It was all before their time, their term, their tenure that began in 2011. It's undisputed that mining stopped on the Peeler Ranch by 2004, and I think it actually stopped, at least in Area A, in around 1990. Coal ash piles at the former lignite mine. That refers to one on the Peeler Ranch, a pile of ash adjacent to in-pit 10, as well as a pile of ash on San Miguel's property that isn't far from in-pit 10. And I believe it's called Area 8A. Former lignite mine ponds. These refer to ponds on the Peeler Ranch in the mining area that Hewitt Mining Group during its tenure had very little to do with. It conducted the inspections required by MSHA that relate to checking embankments, but nothing under the water. Hewitt Mining Group didn't design these ponds, didn't build these ponds, does not maintain these ponds, or did not, I should say, during its tenure at the ranch. Now, let's look at these sub-bullet points under each of these items that we've talked about. Entrainment, and again, we're talking about the sources of contaminants of concern. Entrainment of coal ash and dissolution of coal combustion residuals into surface runoff at the coal ash pile. This is on the power plant property that flows to and accumulates in the yard drainage detention pond, also the power plant property. There is nothing in Mr. Brown's reports that shows any analysis of how he determined that this was a source of contaminants of concern. Let's look at B. Stormwater runoff in this pond is contaminated with CCRs from the coal ash pile, again on the power plant property. Transfer of wastewater contaminated with CCRs from ash ponds A and B to this pond. There is nothing in Mr. Brown's, or for that matter, Mr. Johnson's files that show how any of these items were determined. What I found in their files was an outline that looks just like number 3. And
Files.
pardon me?
You said what you found in their files? Whose files?
Mr. Brown's file.
Okay.
And also, I believe, in Mr. Johnson's file. And it's just a 1-page typed up outline that looks just like this. And there is no working paper that I could find where this was put together. Let's look at number 5. What are the pathways? And I know we skipped a number. That's the way it was in the report. What are the pathways by which the contaminants of concern migrate from the sources and contaminate the Peeler Ranch? Coal ash pile at the power plant. And the subheading under that, infiltration of precipitation and dust control water and subsequent dissolution of CCRs into percolating water that recharges groundwater and subsequent downgradient flow of groundwater to the east. This was part of the 1-page document that I referred to a minute ago. There are no scientific work papers that show this. Somebody might have looked at a picture and thought of all the ways that pollution could occur, contamination could occur from the operation of a power plant, coal-fired power plant, or a lignite mine. But there are no work papers that I was able to identify that showed how any of this was determined. And there are certainly no work papers that identify any contribution by Kiewit Mining Group to any of these things other than for a period of time, Kiewit Mining Group placed coal ash on the pile at N Pit 10 in the lignite mine. But this infiltration of precipitation and dust control water and subsequent dissolution of CCRs into percolating water that recharges groundwater and subsequent downgradient flow of groundwater to the northeast, to the extent my client had anything to do with it, is just utter speculation, unsupported by any scientific analysis. Same thing with the lignite mine ponds. Utter speculation, unsupported by any scientific analysis. I want to share an image that comes from a pond identification map next. Are you able to see that image, or do I need to reshare the screen?
If you could do what you done last time, and yes, just maximize your Word document, I think we'll be able to see it a lot better at least.
Okay. Let's try it this way, and I'll just move it around.
Is this in your motion?
Yes, Your Honor.
What page?
I take that back. This one is
Okay.
not.
All right, go ahead.
this is just for orientation purposes. I can send it to you on the chat. But in yellow is the power plant. If you can see my cursor, the little cross, the ash pile at the power plant is about right here. Can you see where my cursor is, Your Honor?
Yes.
Okay. Just for orientation purposes. All right. This is the ramp 10 pit. You can see there's part with water in it. You can see the white, which is coal ash. This red line is peeler property. Below this red line and to the right is San Miguel property. So the other ash pile that is being referenced is this one here, where my cursor is, right above the ramp 8 pit, that is on San Miguel property. Okay, now my cursor is on the haul road that runs past the area that's labeled as Pond 6, runs past the area that's labeled as Pond 7, and then runs to the roughly to the north past the area that's related to the B1 pond, although I believe I took a wrong turn and it's below the B1 pond is where the main haul road runs. Do you see that cursor?
Yes, sir.
Over into area B. Okay.
I figured out how to zoom in on Zoom. I didn't realize you could do that. So go
Okay.
ahead.
Good to know. So under Mr. Brown's theory, as stated in that summary of his opinions, water, either from rain or from dust control, which Hewitt Mining Group doesn't do unless it's actively operating on a site, encounters this large pile of ash, runs down this large pile of ash, gets into this end pit that I believe is a few hundred feet deep, and then percolates through the groundwater over here, let's say toward Pond 7, past the haul road, which is bermed. It's got 4 or 5 foot tall berms on either side of the haul road. The haul road's sort of the boundary of the mining area, the area that's subject to the mining lease. And then it goes over here. And the problem is Mr. Brown does nothing to scientifically test that any ash, or to scientifically confirm that any ash placed on this pile by Hewitt Mining Group roughly between 2012 and July of 2016 took this path, which again is down into the water, percolates into the groundwater, travels half a mile or so, and winds up in an area that purportedly contaminates off-lease property. There is no causal connection there. Or any place else on the Peeler's property. I just picked the sort of the closest shot from the ash pile in pit 10 off the leased property onto other Peeler-owned land. There's some discussion in there about in one of the reports, and I don't think it's Brown, about some sort of blowing dust from coal ash, either coming from the haul road or from the ash pile. But I believe Brown's report doesn't or expressly says that it doesn't have anything in there about airborne, contains no opinions or conclusions about airborne contamination that would blow through the wind over here or on a non-leased area. Okay, the other part of the Brown report that Brown points to, and we'll talk about that more in a minute, but he points to Kiewit's sloppy practices in removing coal ash from this pile. Again, I'm over here, my cursor's on the power plant site in this area, if the court can see it.
Yes.
Keep in mind that surrounding this power plant site, which is not Peeler land, obviously, is this 902-acre buffer zone lease that surrounds the power plant property that's approximately 300, a little over 300 acres. So under their theory, Kiewit Mining Group would have had to have done something to cause contamination to leave the power plant site, leave the buffer zone site, and get on to non-leased property. What Mr. Brown points to in his report is an email that somebody from San Miguel, the power plant operation, their environmental manager, sent to Kiewit people that complained about their failure to remove coal ash from the power plant on a daily basis. Now, first of all, this coal ash sat here in this pile on a daily basis. And there's discussion in the Brown report about that coal ash contributing to contamination of some kind. Again, Brown does no scientific analysis at all to determine that whether coal ash that was just sitting in this pile migrated off the power plant site somehow to an area that was outside the buffer zone lease, to an area that was not subject to any lease at all, much less anything caused by Kiewit Mining Group's failure to periodically remove it. And this is significant because Mr. Brown goes out of his way. Have I stopped sharing the screen now?
No, but I'll do it.
No, it's not. Okay, let's stop it.
I stopped it. Go ahead.
Okay, thank you. This is significant because Mr. Brown, in one of these late declarations, the one that was filed in connection with the response to these motions, includes sworn testimony or purportedly sworn testimony that there is evidence of contamination caused by Kiewit Mining Group based on Kiewit Mining Group's failure to remove coal ash on a daily basis from the power plant. That's what he points to. He ignores the deposition that was taken of the San Miguel environmental manager who sent the emails complaining about Kiewit's failure or alleged failure to remove coal ash on a daily basis from the power plant, who testified in effect that Kiewit never created any environmental issue as a result of the failure to timely remove coal ash, and that he was complaining in order to act proactively to avoid creating any environmental issue. Mr. Brown completely ignores that. Mr. Brown also points to testimony by a representative of Kiewit Mining Group, Simon Zulu, to establish purportedly that Kiewit Mining Group actually deposited coal ash into the water at in pit 10 instead of on the pile at in pit 10. That is just an utter fabrication. It doesn't, Mr. Zulu did not testify to that. We'll look at that in a minute. I wanted to call the court's attention to this supplemental designation that is some 42 pages long without exhibits that was attached to the Peeler's response to these motions. This is their most recent supplemental designation. And I will share the screen here. Can the court see paragraph 98?
Let me zoom out. I'm zoomed in too much. Yes.
Okay. If you look right above that, he says, finally, we established causation by KMG, paragraphs 92 to 95 herein, and Brown 2020C. I couldn't figure out what Brown 2020C referred to, but this is his summary of the causation he thinks he established of contamination by Kiewit on the property. Now, first he criticizes in paragraph 92, and this is on page 34 of his declaration, a supplemental declaration. He talks about if we had objectively read reports, we would have seen the sequential and reinforcing nature of information and data coal contamination in general, regional background information, local background information, operational history, and site infrastructure. He testified in his deposition, and I think I've already said this, that he observed on one day Hewitt Mining Group dump trucks traversing the haul road. Nothing consequential. Contaminant releases, an abbreviated chronology, determination of background, contaminant of concern criteria. Mr. Sutherland covered that earlier. Data from recent site investigations, interpretation, analysis of that data, interpretations of current hydrologic conditions, interpretations of current contaminant conditions, an assessment of contaminant sources and pathways, presentation of opinions and the bases. And he believes he's provided a reliable foundation. If you look at 94, he's responding to our supplemental motion to exclude. KMG goes on to specifically identify an item from the chronology section of my expert report that documents its very sloppy coal ash handling practices at the power plant. The documentation of these poor handling practices was not my opinion. Rather, it was a statement of fact outlined in an internal San Miguel email included in my expert report. And there was an internal San Miguel email included in his expert report. We'll look at that in a minute. Then he goes on to talk about an internal or an appendix that includes well testing data that has nothing to do with this ash and no connection with this ash to that data. And then he refers to his own Appendix C, and had they thoroughly reviewed my expert report, they would have found that PDF pages 2338 to 2340 is the San Miguel email detailing the very sloppy coal ash handling practices. Now, let's stop there for a second and look at Mr. Sheffield's testimony. And just so we're sure we're on the same page, what I'm showing you now are the pages from Mr. Brown's appendix to his report that he was referring to in that section that we just read that begins at page 2338. Can you see the email, Your Honor, that is from
Yes.
Derek Brumick, dated May 11, 2016 at the top?
Yes.
Okay. All right, if you scroll down, Mike Kezar, Mark Schilling, who's the San Miguel environmental manager. Mr. Kezar is the general manager. Then there's Stephen Mullaney at Kiewit. If you go down to the next email, this is an email from Mr. Kezar to Mr. Schilling that is complaining about Kiewit Mining Group not properly removing coal ash from the pile in order to haul it back to the mine, and that the coal ash pile was too high. And if you scroll down, to the message that is May 11, 2016, 9:38 a.m. from Mark Schilling. This is the email that starts the chain. Mark Schilling to Stephen Mullaney. Subject ash pile. Steve Kiewit is slipping again, trucking ash away from the plant. As you can see in the photos below, the pile is starting to encroach on the drainage areas again, and this needs to stop. Please make sure the trash is moved ASAP. Okay.
Okay.
Next, I want to go to Mr. Schilling's testimony. Oops. Bear with me. These are excerpts from Mark Schilling's deposition, December 19, 2019, which, by the way, Mr. Brown would have had access to certainly by his rebuttal report date several months later, but possibly even by his original report date, which was, I believe, the end of January of 2020. And I asked him to pull out exhibit 337. This exhibit dealt with a complaint you had about Kiewit's delay in removing ash from the property, right? And you're concerned it might get into the drainage area. Yes. Can you tell me whether or not any ash actually got to the drainage area as a result of this complaint or any similar complaints that you ever had? Answer: nothing. This was a proactive approach on my part to make sure we didn't have, that this did not become an environmental issue. And in another exhibit email, he was concerned about a potential environmental issue. And I asked him, can you tell me whether or not there ever actually was an environmental issue created for San Miguel as a result of any delay by Kiewit removing ash from the plant property? Answer: not to the best of my knowledge. Mr. Brown completely ignores that and points to this email as evidence of causation of contamination by Kiewit. And again, setting aside the migration issue about how we show that contamination got from the middle of the power plant site to some area on the Peeler Ranch that is not subject to the mining lease or the buffer zone lease. Now, let's look at paragraph 95. He's talking about Kiewit building a land bridge in 2020, or I'm sorry, in 2012. And then he says, once the west cell was dewatered, Kiewit started to place coal ash into the west cell. And he cites Simon Zulu's deposition, and ash was placed into the west cell from 2012 to 2016, which, if you read this in context, the area A final pit is the water-filled pit. And he's saying that a land bridge was built. San Miguel pumped water from one of the cells to the other. Once the cell was dewatered, Kiewit started to place coal ash into the west cell. This demonstrates that KMG had a well-defined role in creating a source of contamination, the coal ash from 2012 to 2016. The groundwater flowing through this coal ash will dissolve COCs and transport those away from the ramp 10 pit, down gradient beneath the lease area and beyond the lease boundaries. Now, he does nothing to scientifically prove this sentence in any of his reports. There's no tracing. There's no calculation. It's just a bare ipsa dixit, because I said so. Groundwater flowing through this coal ash will dissolve COCs, transport those away from the ramp 10 pit. And he doesn't say this, but I'm presuming he means via groundwater. And then it has to go half a mile or more, as we looked at on the map, to get to someplace that would be off the lease property that KMG might be responsible for, but he never gets there. But this statement about placing coal ash into the west cell, citing the deposition of Mr. Zulu, Kiewit Mining Group person, is a fabrication. We're going to look at Mr. Zulu's testimony. Okay, that should be up. Can you see at the top, Your Honor, Simon Zulu, corporate rep, May 2019?
Yes.
All right. This is the page 67 to 68 reference. He is being asked about if you start at line 20, was it? Well, let's back up. Line 16, do you have an understanding, let me ask it this way, was ash being placed on the ash pile? And this is referring to the ramp 10 in pit ash pile in 2015. Yes, I believe so. 2014, yes, sir. Go to page 68, 2016. Then the question was 2014. Answer, yes, I would believe so too. Same question for 2013. That's possibly true. This is information on the ash maps, and my basis is based on that. 2012 was the next question, beginning at line 8. His answer was, I believe that may have been the first year that ash placement was done by Kiewit. Okay. Nothing in the 67 to 68 about placing ash in the water. Let's look at the other deposition excerpt Mr. Brown identifies. And this, can you see this one, Your Honor, that?
Yes.
Okay. From the same deposition, this is page 110. Line 15, earlier I asked you about whether the ash pile at ramp pit 10 was in communication with the water. I believe you said, and correct me if I'm using the wrong terminology, there was a cap or toe cap in place. His answer was, there is a plug or a barrier between where the water is and between the area where the ash is placed at the top of the pile. And what he's referring to there is a land barrier that was constructed along the bottom of the pile to create distance and separation from the water at end pit 10. Mr. Guerrero asked him, what do you know about this plug? The answer was, what I know, and it is not new because it's used more than once in other places. Because it's been difficult for San Miguel to completely get water out of those pits, it's been possible for them to remove water incrementally from one section of the open pit to another as the water goes down. And they will, as you will see this, if you're physically there, you can see what is done is on the north side of the pit, there's a swath of dirt that's been cut out into the pond right at the top of the ash pile in ramp 10. The dirt that's missing on the north side was pushed into the pit to create a land bridge across the pond. Now, here we're talking about dirt. Okay, not ash, dirt. Then he talks about, so there's now two cells of ramp 10, the pit, the one on the east and the one on the west. Because the water was lower at the time, San Miguel was able to move water from one cell into the other cell. So the other cell actually filled up, the other cell had emptied out. That's how that ash ended up on the west side of ramp 10. So this land bridge that was created, I'm referring to as a plug. He changes his testimony, corrected his testimony to change this word from top to bottom. Which I'm referring to as a plug is at the bottom of that ash pile. So below the water level, what you have is a land bridge that separates the ash pile from the side that has water. What you see on the surface is appointed to runoff. Runoff washes the slopes, and it has discarded that section of the land bridge, and he's referring to the land bridge being eroded by runoff. It has discarded that section of the land bridge to where you can't quietly see it, but it is there. And is this something that you've just been able to observe by being out there, or did Kiewit have any role in installing this plug? Kiewit installed the land bridge. When did that occur? I may be off in my years, but I believe in 2012. And then it goes on to ask about design documents. There is nothing on these pages that Mr. Brown cites that stands for the proposition that Kiewit Mining Group pushed ash into the water in pit 10. That's the other principal thing that Mr. Brown points to in his analysis. that it's not just not scientifically supported, it's fundamentally wrong. And so we have a situation now where not only did Mr. Brown not do a scientific analysis to support what he says about Kiewit Mining Group, he is in effect misconstruing, or even worse than that, Mr. Zulu's testimony from Kiewit Mining Group about pushing ash in the water, and completely ignoring Mr. Sheffield's deposition, or I'm sorry, I keep saying that, Mr. Schilling's deposition from San Miguel about this issue of the power plant not creating any sort of environmental problem. And on top of that, there's no causation analysis. So these opinions about the contamination in pathways are non-specific and generically focused on the former mine or mine activities. They're conclusory in terms of the general references to the plant mine infrastructure and the alleged pathways of contamination. No work papers or analysis, no scientific testing to trace these purported contaminant pathways. Like Bowman, at least in Brown's timely filed report, he didn't even offer any specific opinions about Kiewit Mining Group or how its acts or omissions caused contamination outside the lease property. Now, as we saw in his declaration and in his other late declaration, he's tried to come back now and point the finger at my client. And again, those should be, those late declarations should be excluded to the extent they contain new opinions, but even those new opinions don't get them there. Neither Brown nor any expert on which he relies, including Johnson, have done any proper causation analysis that shows that any damage on a relevant area was caused by Kiewit Mining Group. So if the court does not completely exclude Brown's opinions based on the joint motion, it should exclude Brown's opinions about the fact of contamination or the causation of contamination from being offered against Kiewit Mining Group, as the court did with Mr. Bowman, the geophysical electroconductivity expert. I'll note here that the Peelers also attempted to do the same thing with Bowman just before the hearing on the motion to exclude Bowman which was tendering additional declarations many months after the report deadlines, months after their depositions were taken, after the close of the discovery period. And in the case of Johnson's first late designation, months after the declaration was signed, beyond these deadlines that were set by agreement of the parties in court order. The new opinions don't reflect any recent development that would impact their original expert opinions in the reports or their testimony in the depositions. They don't include or reflect any additional work that was done or any change in conditions. So Kiewit Mining Group would ask that the court not consider and strike the 2 supplemental designations that were tendered for Brown. We'll make the same request for Johnson because these declarations, these late declarations, were untimely and by many levels or by many deadlines, and to the extent they contain new opinions, they're prejudicial. Let me look at my notes, Your Honor, real quickly. I think I'm just about done.
Okay. If so, we'll take a break until 12:25 and then we'll get started with Ms. Whittle.
Your Honor, I believe I've covered all the points with Brown. I had the Brown and the Johnson points mixed together, so I apologize that this has been kind of halting, but I was trying to separate our experts.
Okay. That's fine. All right, then we'll come back at 12:25 and start up then, get this wrapped up.
That's fine, Your Honor. Thank you.
Okay, are we all ready?
Ready,
Yes,
Your
Your
Honor.
Honor.
You and mining groups ready?
Go ahead, Ms. Whittle.
Good afternoon, Your Honor. The coal companies attack peeler expert Anthony Brown's methodology for delineating waste contamination at the Peeler Ranch because they do not agree with his conclusions. But that is not sufficient to exclude an expert. It is not the role of the trial court to determine whether an expert's conclusions are correct, but only whether the analysis used to reach those conclusions is reliable. It is the province of the jury to determine which interpretation of the data and methodology was persuasive. They also attempt to set the bar for admissibility substantially higher than the true criteria under Texas law. An expert need not disprove or discredit every possible cause other than the one espoused by him. The Texas Supreme Court made this clear in Transcontinental Insurance Company versus Crump at 330 Southwest 3rd 211. Nor do an expert's factual assumptions need to be uncontested or unassailable as a matter of law. That is because any disputes as to the evidence is within the province of the jury. The coal companies do not challenge Mr. Brown's qualifications in their motions, although counsel for San Miguel and Kiewit today started to do so regarding Mr. Brown's experience with the TERP rule. That is nowhere in their motion, and the court should disregard all of those new arguments. In fact, counsel made many new arguments today that appear nowhere in their briefing. For example, that Mr. Brown has rendered no opinions with respect to salt, electroconductivity, or sodium adsorption ratio, or that his work papers are missing. That is demonstrably not true. But again, the court should reject those arguments because they were raised for the first time today, including the arguments about his figures being highly prejudicial. I urge the court to focus only on the arguments that appear in their actual movement briefs. The suggestion that figures should be struck appears nowhere in their motions, and they did not even file replies. The only arguments made in the motions to exclude were based on methodology, and those were focused entirely on failure to exclude alternate causes. Nor did Kiewit file objections to the declarations attached to the responses. The oral objections were new today, and there is no basis for them. Mr. Brown's declaration specifically responds to each of the arguments made in the motion to exclude, citing both deposition testimony and his expert reports to tie his declaration back to the previously disclosed opinions. In any event, all of the new additional bases for exclusion or objection are untimely under the agreed scheduling order, and almost none of the evidence that Mr. Guthrie showed the court today was appended to its motions. None of it. If the court is going to entertain these new previously undisclosed bases for exclusion, then we ask for an opportunity to submit supplemental briefing to all of these surprise arguments, and that the coal companies not be afforded a similar opportunity since they missed the court-ordered deadline for raising these objections. Just briefly, with respect to Mr. Brown's qualifications, not only were Mr. Guthrie's statements incorrect about his training, he's wrong on a very basic facts. Mr. Brown was not educated in Canada, he was educated in London. I would point to the court to Mr. Brown's resume, which is attachment 1 to his declaration. And I'll share the screen and show the court his resume. It is at PDF page 87 of our response, Your Honor, and his resume goes on for many pages. It describes his training, his experience with 30 years of experience in hydrology, hydrogeology, water resources, water quality, fate and transport of contaminants, groundwater remediation, regulatory strategy, water resources evaluation, and water supply engineering. He explains at length his experience and training, the kind of projects he has worked on, the testimony he's provided both before Congress and before trials both state and federal court. He also describes his teaching experience. I'm just flipping through quickly, Your Honor. He has project experience. And this is the relevant experience to this case. He has his teaching experience, his publications, and presentations that he has authored. He is extremely well qualified, and the surprise arguments today that he is not qualified should be disregarded by the court. While Mr. Brown is not a professional engineer licensed in the state of Texas, Peeler experts Gordon Johnson and Dr. Lauren Ross are licensed professional engineers, while San Miguel's main expert Mark Hemingway and Kiewit's main expert Simon Zulu are not. Mr. Brown's report and deposition testimony are clear that his analyses did consider and then rejected each of the alternate sources that the coal companies argue he ignored. They are also inaccurate in asserting that Mr. Brown failed to use appropriate forensic techniques in considering these alternatives. In fact, Mr. Brown testified that he did apply one technique they suggest and determined that the other could not be properly applied under these conditions. Their attack on Mr. Brown's supposed reliance on Canadian electrical conductivity and sodium adsorption ratio criteria misrepresents Mr. Brown's work. In his deposition, Mr. Brown made absolutely clear that he relied on the presence of excess levels of chemical constituents such as boron to reach his conclusions about the extent of contamination. He did not rely solely on electroconductivity or sodium adsorption ratio measurements to determine the bounds of contamination. Instead, Mr. Johnson, a different Peeler expert, relied on the regulatory standards that the coal companies dislike, along with many other sources to determine a threshold of salinity for his remediation program, which is fully contained within the bounds of the contamination extent that Mr. Brown identifies. For example, Mr. Johnson relied on a Texas A&M publication, a draft Railroad Commission guidance document that is almost always relied on by environmental consultants in Texas cleanups, the soils map generated by the United States Department of Agriculture, and site-specific soil sampling results, both from this investigation and from San Miguel's historical sampling done as part of its permit applications. The motion's repeated dismissive references to the EC and SAR threshold values selected by Peeler expert Gordon Johnson as Canadian is a misleading attempt to confuse the court when in fact the relevant threshold values were selected through a careful analysis of multiple lines of evidence, including studies by Texas A&M on grasses that actually grow on the Peeler Ranch. But to be clear, Mr. Brown, the expert at issue in this motion, did not rely on the threshold that Mr. Johnson used for his remedial program to delineate the extent of waste contamination. Delineation of waste contamination came first. A decision about how to restore the Peeler Ranch in an economically feasible manner to use so the Peelers can use it as a cattle ranch came second. The coal companies are also factually wrong in asserting that Mr. Brown designated areas as contaminated even when there was no sampling data or other objective scientific support for this conclusion. In fact, Mr. Brown meticulously distinguished areas where multiple lines of evidence supported the presence of contamination from areas where contamination might be present but could not be confirmed. The coal companies lump these areas together and try to ascribe their own errors to Mr. Brown. Mr. Johnson's conclusions regarding areas requiring remediation focus on the core area that Mr. Brown identified as contaminated. That is, where contamination was confirmed by multiple lines of evidence and where the indicator constituents show a contiguous pattern of contamination. That's where remediation was focused and what the Peeler's damages are based on, which of course are capped under Texas law in any event. It ends up being a quarter of the size of the area that Mr. Brown has opined likely has waste contamination present. The fact that Mr. Brown himself identified peripheral areas where some evidence indicated contamination demonstrates the reliability of his methodology and conservative nature of his conclusions, directly contradicting the coal company's position. Your Honor, we have attached a sworn declaration from Anthony Brown responding to each of the arguments made by the coal companies and citing back to his reports and deposition testimony. There are no new opinions in this declaration. He's simply responding to their arguments and pointing to where he explained his position previously. And in his declaration, he cites to his report and deposition testimony for those statements. As to their argument on his failure to consider alternate causes, Mr. Brown's testimony and report make clear that he considered each of the possible alternative causes and more, and concluded based on the evidence available that none of these was a significant factor contributing to the contamination he identified. At most, the coal companies have identified areas for cross-examination, but have provided nothing to support striking Mr. Brown's opinions, which are relevant, reliable, and will assist the jury. Mr. Brown was asked directly at his deposition if he had considered the possibility of other causes for the observed contamination, and he confirmed that he had performed the necessary analyses. That testimony is attached as Exhibit 1 to our response, Your Honor. Mr. Brown confirmed that based on these analyses, he, quote, could not identify any potential alternate source that would account for the observed contamination. He further testified that he performed evaluations of potential contribution of both the oil and gas activities as well as what we refer to as the artesian well, but concluded that those activities did not contribute to the contamination that we have delineated at the Peeler Ranch. The coal companies provide no support for their position that an expert must use certain techniques or be deemed to have failed to evaluate obvious alternate sources of contamination. None of their cases support their position, but instead each addressed an expert who failed to use any method to assess alternate explanations. That certainly is not the case for Mr. Brown. His report and testimony are clear that Mr. Brown expressly considered each of the other possible sources of contamination they suggest, and he has explained why he concluded that those sources did not contribute significantly to the contamination he identified. With respect to oil and gas operations as an alternate source, their allegation that these oil and gas activities are contamination sources is raw speculation. In fact, there is no evidence of any spill ever on the ranch that could deposit the type of contamination Mr. Brown used to delineate the contaminated areas. And San Miguel's expert, Mark Hemingway, admitted that was the case. Even after an extensive and thorough effort at discovering such a spill by San Miguel to each and every one of the operators who have ever operated on the Peeler Ranch, Mr. Hemingway, San Miguel's own expert, independently concluded that the contamination on the ranch was not caused by oil and gas activities. In fact, Mr. Brown performed several types of analyses to assess the potentially contaminating oil and gas activities, and has explained why he concluded that they did not cause the observed contamination. His testimony about this process is attached to our response, and his declaration at paragraphs 11 through 39 explains it as well, with cites to his reports and deposition. First, he compared the observed distribution of contaminants to the location of oil and gas wells and other infrastructure to determine whether elevated levels of contamination correlated with proximity to oil and gas activities. He testified that we would anticipate that if oil and gas activities had contributed to contamination, one would expect to see areas of contamination more distant from the power plant and lignite, but we do not. We only see contamination proximate and down gradient of the power plant and lignite mine. Second, He relied on constituents not found in petroleum when delineating contamination from San Miguel's coal ash wastewater. Third, he evaluated whether any reported spills or releases from the oil and gas activities of materials could contain the constituents used to delineate contamination. Fourth, he examined groundwater monitoring well samples previously taken to the oil and gas operations to determine whether petroleum hydrocarbons were present. In his declaration at paragraph 33, he explains that the absence of petroleum hydrocarbons in groundwater samples confirms that releases from oil and gas infrastructure have not contributed to the contamination at and down gradient of the SMEC power plant and former lignite mine. And he points to table 11 in his report for those results. Fifth, he specifically assessed the presence and distribution of barium, which is widely accepted as a marker for oil and gas contamination, in the soil samples to evaluate the likelihood that oil and gas contamination had occurred. These various analyses uniformly failed to provide any evidence that oil and gas activities contributed to the contamination Mr. Brown's work has identified and delineated. So Mr. Brown properly rejected that hypothesis. The coal companies claim that oil and gas activities might cause a spill ignores the clear Texas law that an expert is not required to rule out every possible alternative for her testimony to be reliable and admissible. In this case, San Miguel itself engaged in extensive discovery on oil and gas related spills on the Pila Ranch and discovered only one pipeline release to the northeast of the plant. The motion fails to recognize that even ubiquitous oil and gas activities are not contamination sources unless there is a spill. As Mr. Brown explains at paragraph 16 of his declaration, quote, "I have no information to suggest, and the data does not indicate that such an unreported spill has occurred. To suggest an unreported spill could result in the widespread contamination at and down gradient of the SMEC power plant and former lignite mine would be speculative and preposterous," end quote. If we had done that, just pointed to the plant and the mine and said that ash ponds, coal ash mine fill, and mine impoundments are generally known to cause contamination. So they did here. End of story. The court would have poured us out. The coal companies have not pointed this court to any evidence of oil or gas related spills that could result in the observed contamination. Neither do their experts. As to the particular spills which actually have occurred, Mr. Brown considered each of these and has explained the analytical basis for his conclusion that they are not relevant to the observed contamination. The only known drilling-related spills on the ranch consist of crude petroleum, which does not contain the contaminants Mr. Brown relied on to delineate contamination. Though drilling muds and produced water could contain some of the constituents Mr. Brown used to delineate contamination, there are no reports of spills of drilling muds or produced water at the Pila Ranch, and the actual data do not support speculation about such spills. You'll note they never provide any actual evidence of such spills. The coal companies argue that Mr. Brown allegedly did not use certain specific techniques which they believe would be appropriate to rule out alternate sources of contamination. And they rely on a case from the Northern District of Florida where an expert's use of a methodology that could not distinguish between the various possible sources of contamination weighed against admissibility. But that isn't what happened here. Mr. Brown applied appropriate analytical tools to evaluate each of the possible alternate sources of contamination present on the Pila Ranch. Mr. Brown either considered the techniques that the coal companies argue he should have used, or he found them to be inappropriate in these circumstances. As to trend analysis, Mr. Brown testified at his deposition. Unfortunately, the wells that have been installed in the area with observed contamination have only been sampled a few times. So there's insufficient data for those wells to perform a trend analysis. But given the trial delay, we may well be able to gather sufficient data to do that work if allowed to supplement, which would allow for a trend analysis. And it is worth pointing out that even though the coal companies claim that Mr. Brown's testimony is unreliable because he did not use the particular techniques they think he should have, San Miguel's expert, Mark Hemingway, did not either. He did not deem any of it necessary. And you heard Mr. Sutherland claim that Mr. Hemingway is well known as one of the best environmental remediation experts in the entire state of Texas. Whether that's true or not, he was able to identify contamination from San Miguel's operations without using those specific techniques. Turning to the artesian well, which the peelers refer to as the Oppenheimer well. Mr. Brown ruled out the well as a cause because it is located north and mostly down gradient of all of the regions he designated as contaminated. And furthermore, because analysis of the water coming from the well demonstrated that the well water contains a lower concentration of the relevant constituents than the contaminated area, meaning that flow of this water into the designated area actually would decrease contamination levels. He explains this view in his declaration at paragraphs 40 to 49. The coal companies misconstrue his testimony about the area of impact of the artesian well to argue that he is mistaken about the flow of the well's drainage. Mr. Brown did testify accurately that the drainage from the artesian well enters La Perita Creek around sampling point SW14, or just to the east of that. Mr. Brown subsequently verified this description in his declaration at paragraph 42, where he states the drainage from the artesian well enters La Perita Creek east of southwest or SW14, approximately 0.45 miles northeast of SW14, and approximately 0.20 miles northwest of SW17. While SW14 and a few other sampling points are located in the general vicinity of the artesian well runoff, they are uphill of the well. These sampling points only could be affected by the well if the well water flowed toward them, and that would require water to run uphill. As Mr. Brown confirmed in his declaration, the discharge from the artesian well does not flow into the area that I have delineated as contaminated. Therefore, it could not have contributed to this contamination. This is not new. He testified at his deposition that the, quote, discharge from this artesian well may contribute clearly TDS to La Perita Creek, but it does not contribute to the area of contamination that we've depicted with both soil and groundwater contamination. Mr. Brown also testified that he performed specific analyses to confirm whether the artesian well might have caused the observed contamination. He testified that he evaluated the chemicals that were detected in the sample of well from the artesian well to identify whether the water flowing from that well contained any of the constituents of concern above the background concentrations, such that it could be contributing to a portion of those constituents to the observed contamination. In evaluating that data, it was evident that the constituents of concentrations in the water flowing from the artesian well was in fact below the baseline criteria. Therefore, it was not contributing to the contamination. He also explains this in his declaration that there is no evidence of the flow rate of that artesian well over the years. Mr. Peeler testified that in times of drought, which is a lot of the time, the well does not flow. So counsel for San Miguel's assumption that the flow rate has been constant for over 100 years has no basis in fact and is not scientifically supportable. In any event, Mr. Brown expressly considered and ruled out the possibility that the artesian well caused the observed contamination based on specific evidence, that the well discharge does not flow toward the area designated as contaminated, and furthermore, that the water well's composition of contaminants falls below the background level for all constituents used to detect contamination. And Your Honor, you asked for an image of where the artesian well is located as compared to areas of contamination. And I will share my screen to show that to you. This is the Oppenheimer well, Your Honor, and it flows into La Perita Creek north of the areas of contamination. Just to give you that depiction. With respect to the caliche used on the Peeler Ranch roads as an alternate source, Mr. Brown's analysis revealed that the roads through the ranch, including the haul roads and roads leading to ash piles, in fact, have low soil conductivities, indicating that they are not a significant source of contamination. I would like to look a little at the Mitchell Energy case, the one Texas case that Counsel for San Miguel has discussed this morning. First, the words highly improbable do not appear in the case anywhere. Second, the issue in the Mitchell Energy case is that the expert did not provide sufficient evidence of causation. Here are a couple of pages from the case, Your Honor. As to causation, the court held, here, Your Honor, we hold that the 1976 test results, which showed only that hydrogen sulfide was present in 2 of Mitchell's gas wells on a single day and was absent a month later, are no more than a scintilla of evidence. Such evidence is legally insufficient to allow a reasonable juror to conclude that hydrogen sulfide from Mitchell's gas wells polluted Apelli's water supply. This is really what was motivating the court, that the expert did not have sufficient evidence to support his claim of causation. In addition, he had done no work to rule out alternate possibilities. So he, while he had reviewed isotopic data from 4 of Mitchell's gas wells, he did not gather any evidence at all about the chemical makeup of the other gas wells, even though Mitchell was one of 22 operators with gas wells in the area. He also did not rule out the possibility that hydrogen sulfide could have been caused by bacteria introduced on the surface of the wells. And Mr. Mitchell, the expert, sorry, Dr. Bassett, had basically agreed that he hadn't done enough. So here, the conclusion, because Dr. Bassett did not present more than a scintilla of evidence that hydrogen sulfide was present in Mitchell's gas wells, and because Dr. Bassett did not rule out the other possible causes of hydrogen sulfide in Apelli's water, his testimony is no evidence that hydrogen sulfide from Mitchell's wells had polluted Apelli's water. So that is not the case here, Your Honor. Our experts have done significant work to demonstrate causation from San Miguel's operations, and they have done significant work to rule out alternate causes. The coal company's argument that Mr. Brown incorrectly portrayed the natural background salinity of the soil misconstrues his testimony. Today, Mr. Sutherland suggested that Mr. Brown ignored all of this, but that wasn't quite their argument in their motion. Mr. Brown correctly characterized the surface level soil layer from 0 to 6 inches below the ground surface in creeks and drainage areas on the Peeler Ranch as having a natural salinity of 100 millisiemens per meter to 200 millisiemens per meter. This value describes the dominant soil type, USDA type 6, covering the drainage areas. In their motion, the coal companies present a lengthy and detailed attack of this characterization that relies on salinities from deeper soil layers to supposedly prove that Mr. Brown is wrong, when in fact his assessment only addressed the top 6 inches of soil. Mr. Brown's analyses accurately recognizes that soil conductivity increases at deeper levels. This goes to the question that Mr. Sutherland asked today. Why didn't he use the same type of sampling methods and analyses that Dr. Ross did for the other metals for soil conductivity and SAR? by improperly comparing Mr. Brown's description of the very top layer of soil to data from the deeper layers, they invent a supposed error in Mr. Brown's methodology that simply doesn't exist. The motion's comparison of Mr. Brown's testimony regarding the surface soil layers to Dr. Ross's analysis of background sampling data suffers from the same flaw. Her calculation of the upper bound of natural background conductivity is from all depth intervals rather than the top 6 inches alone. And salinity increased significantly with depth, whereas the other, that wasn't true necessarily with the other constituents. More importantly, Mr. Brown did not rely upon the contested background salinity levels in reaching his conclusions. The coal companies call it foundational to his opinions, but that is simply not true. Mr. Brown has been absolutely clear that he relied upon elevated concentration of metals to identify the extent of contamination. He relied primarily on the extent of boron analysis to delineate the area of waste contamination, and he describes that at paragraph 60 of his declaration. As for their argument that he supposedly designated areas as contaminated where he had no sampling or other objective scientific evidence, Mr. Brown clearly distinguished between 2 different areas he designated as contaminated. He explains this process for the court at paragraphs 69 through 83 of his declaration. First, he delineated the extent of contamination zone, which was supported by multiple lines of evidence with a solid pink line. Separately and in addition, he delineated 3 small areas counter-defendants complain reflect unreliability with a visually distinct indicator, a dashed pink line. In the latter areas, elevated soil electroconductivity suggests potential contamination, but the soil sampling was insufficient to determine whether these areas were in fact contaminated. Essentially, the peelers got to a point of diminishing returns. They've spent so much money on this site investigation, and where their recovery is capped, to continue to prove further and further contamination with additional soil sampling wouldn't add anything to their recovery. Mr. Brown clearly marked these areas with a different type of line to highlight the uncertainty regarding contamination in these areas and to distinguish them from his main contaminated region, for which multiple lines of evidence confirm contamination is present. And it's worth noting that now that San Miguel has begun one response action in an area of elevated electroconductivity, it has become clear that the contamination in that area is far worse than was suggested by the elevated electroconductivity, and we would expect that to be true across the ranch. Mr. Brown himself distinguished the areas the coal companies claim demonstrate the unreliability of his results. He himself has reported the potential uncertainty in those results, and the remedial program developed by Mr. Johnson is limited to the areas within the solid pink line. The motion on Mr. Brown also raises the same issue regarding peeler expert Gordon Johnson's selection of threshold levels for electroconductivity and sodium adsorption ratio. Mr. Johnson's carefully selected this threshold level through a rigorous analysis of multiple lines of evidence, and I will explain that further in the argument on the motion to exclude Mr. Johnson. But as Mr. Brown testified repeatedly, he did not rely on those areas to delineate his areas of contamination that require remediation, but instead used them to identify areas to investigate further. His conclusions about known contamination are based specifically on elevated concentrations of metals, such as boron. And again, that testimony is attached to our response. He reiterates his explanation at paragraph 60 of his declaration. Mr. Brown explains that he considered the EC and SAR exceedances as 2 of the many indicators of potential contamination he examined. But when it came time to make conclusions about the scope of contamination, Mr. Brown did not rely on the EC and SAR data alone. Instead, he based his conclusions on the presence of elevated individual constituents of concern. The coal companies argue that there are 6 areas where the only data supporting contamination are the electroconductivity and SAR values. One of the areas in question, location SW20, in fact is outside the extent of all contamination boundary. For 2 more areas, Mr. Brown recognized that although the EC and SAR data indicate potential contamination, insufficient data were available to reach a final conclusion. So he was careful to distinguish these areas with a separate indicator, a dashed line, to make clear that their contamination status is less certain. The remaining 3 regions the coal companies dispute are entirely surrounded by all sides by areas in which soil samples definitively demonstrate elevated concentrations of various metals. These small areas are wholly surrounded by data points demonstrating contamination. That justifies Mr. Brown's conclusion with a reasonable degree of scientific certainty that they are more likely than not also contaminated. The coal companies also argue that Mr. Brown's methodology is unreliable because he identified an area of contamination that is larger than the region where boron exceedances were observed, even though he testified that boron exceedances were the primary indicator he used to identify soil contamination. But as he testified, he examined numerous lines of evidence to discern the presence of contamination. The larger solid pink zone of all contamination illustrates the area in which various lines of evidence indicated that contamination was present. However, not all of this region revealed consistent contiguous patterns of contamination for the various indicator constituents. So Mr. Brown also delineated a much smaller area, the extent of boron contamination, that met his more stringent criteria of consistent, contiguous patterns for the indicator constituents. Mr. Johnson's remediation program focuses on the smaller area. Mr. Sutherland today stated that he had questions for Mr. Brown on why he focused on this test. He should have asked Mr. Brown that at his deposition, and he certainly can do so on cross-examination. Rather than suggesting some unreliable methodology, the fact that Mr. Brown himself identified where support for the presence of contamination was more or less definitive and delineated a smaller area where the data were conclusive demonstrates the reliability of his analyses. And just to show, Your Honor, again, this is the figure 47 of the estimated extent of soil contamination. There are similar figures in Mr. Brown's supplemental report for the extent of groundwater contamination. Mr. Guthrie's suggestion today that somehow Mr. Brown didn't delineate groundwater contamination was confusing, because he certainly did. So here, Your Honor, there's the solid pink line that shows the extent of all contamination. And then there is a dashed pink line that shows where there aren't sampling results in these areas, but they show conductivity, elevated conductivities, and the property itself appears to have been scarred. If you note, Mr. Johnson's remediation program, which is this area here and this area here, and the smaller area here, is fully contained within the smaller extent of definitive soil contamination. And the peeler's damages, what it would cost to restore this property, are based on these smaller areas that would need to be cleaned up to restore the property to a cattle ranch. So only basically allowing constituents to remain in place and creating a layer on top that would serve as appropriate cattle ranch. Now, Mr. Brown's opinions regarding Kiewit are also reliable. Mr. Brown has used the same process that Kiewit challenges as unreliable to define the extent of contamination at hundreds, if not thousands, of contaminated sites. As Mr. Brown explains in his declaration, quote, "It is the process used to define the extent of pollution used in the environmental consulting profession, especially at sites where regulatory standards have not been set for a particular constituent of concern," end quote. He states at paragraph 86, quote, "Contamination at the Peeler Ranch consists of salts and metals. And at Peeler Ranch, salts are present at concentrations that make natural resources unfit for use, and metals are present at concentrations above established background criteria." He explains that salts are harmful because they cause soil to become less permeable and damage or kill plants. Mr. Brown's report provides a reliable foundation, evidence supporting material factual assumptions, the bases for opinions, and a summary of the opinions that relate to the harm. That is, the contamination at Peeler Ranch associated with San Miguel's power plant and former lignite mine. It is absolutely scientifically supportable and very robust. With respect to KMG, Mr. Brown identified in his report and his deposition the poor coal ash handling practices by KMG at the plant. Moreover, KMG built a land bridge in 2012 to allow for additional ash disposal on the Peeler Ranch. Then Kiewit placed ash on the Peeler Ranch from 2011 to 2016. Mr. Brown concluded this demonstrates that KMG had a well-defined role in creating a source of contamination, the coal ash, from 2012 to 2016. The groundwater flowing through this coal ash will dissolve COCs and transport those away from the ramp 10 pit down gradient beneath the lease area and beyond the lease boundaries. While Mr. Brown does not purport to delineate the proportionate share of KMG's liability, given KMG's operations at the site, it is his well-supported and reliable opinion that KMG has contributed contamination to areas beneath Peeler Ranch, including both the leased areas and areas extending beyond the lease boundaries. The jury will determine which parties are at fault based on a preponderance of the entirety of the evidence before it, not only Mr. Brown's expert testimony. As explained in prior briefing on this issue, no one expert has to do all of the work for the Peeler's case in chief, and the jury may consider expert testimony along with fact testimony and other evidence to answer questions as to liability for each cause of action, proportionate share of liability, and damages. And just to go through the facts a bit, since Mr. Guthrie attempted to cabin KMG's contribution to the harm, even after he cited to the court the case law that says KMG is liable if its actions are a substantial factor in bringing out the damages. Now, Ms. Kiewit has filed a motion for summary judgment on the tort and
All
statutory
right, and I need to interrupt you for a moment because it looks like we have everyone here. It's 8 after the hour on the Micah Rodriguez case. How much longer, Ms. Whittle, do you expect?
I think I only need 15 to 20 more minutes, Your Honor.
Okay. All right, so I'm going to ask the parties in the Rodriguez child case to be ready at 1:45. You're welcome to hang out and listen. You're welcome to do something else, but we'll try and pick that up at, let's make it 1:50.
Yes, Your Honor. Thank you.
Thank you, Your Honor.
Go ahead, ma'am.
Yes, Your Honor. Kiewit has filed a motion for summary judgment on the tort and statutory causes of action that will be heard at the end of next week. But to shortly rebut Mr. Guthrie's arguments, which again were not raised in the briefing at all, Kiewit was the mining contractor for San Miguel at the San Miguel lignite mine from January 2011 to July 2020. During its tenure as the mining contractor for San Miguel, Kiewit disposed of coal ash in the San Miguel lignite mine, both on and adjacent to the Peeler Ranch. From 2011 to 2016, Kiewit disposed of coal ash on the Peeler Ranch. After mining completed at Pit 10, which is on the Peeler Ranch in 1990, instead of reclaiming the pit promptly, San Miguel deliberately filled it with water to drain Pond 8 in order to resolve a notice of violation from the Railroad Commission, and then continued allowing Pit 10 to fill with water, which remains pooled in the pit to this day. In 2010, Kiewit constructed an earthen land bridge across the flooded Pit 10, dividing it into 2 cells. San Miguel emptied one cell by pumping water across the land bridge into the other cell. Kiewit, at San Miguel's direction, subsequently filled the dewatered cell and adjacent areas with coal ash. Because Pit 10 was flooded and unavailable for coal ash disposal until 8 years after all mining ended on the Peeler Ranch in 2004, all ash piled in and adjacent to Pit 10 by Kiewit must be derived from other properties' lignite. The Peeler lease does not allow San Miguel to dispose of coal ash waste derived from lignite mined outside the Peeler Ranch boundary or any other solid waste on the Peeler Ranch. According to San Miguel's own experts, coal ash contains an increased concentration of metals and other constituents found in lignite that have caused damage to human health and ecosystems, and water flow is a mechanism for transporting these contaminants. When water comes in contact with coal ash, minerals from the ash dissolve into the water until they reach some maximum level of proportion to what's in the coal ash. Introducing additional amounts of coal ash necessarily introduces additional volumes of toxins, which in turn increases the degree to which these toxins migrate into and contaminate the surrounding environment. The record in this case is replete with evidence that toxins are and have been migrating out of the ramp Pit 10 ash pile and into the surrounding soil and groundwater, harming vegetation and posing an ongoing threat to humans and the environment. Kiewit's corporate representative testified that rainwater travels over and through the ash at Pit 10 and into the Pit 10 water as runoff, which then seeps into nearby ponds through fractures in the pit, and that by design, this water is discharged over the Peeler Ranch outside the lease boundary. San Miguel's general manager testified that groundwater is in contact with the ash that San Miguel and its mining contractors placed in the bottom of the Peeler mine pits. He further confirmed that coal ash is distributed through the spoil used as fill in Area A. Now, prior to Kiewit placing the ash at Pit 10, which Mr. Guthrie went through today, Kiewit was aware of this water problem and the seepage problem, and yet disregarded it. So it knew or should have known the harm that would cause from placing additional ash in proximity to the water that was then being discharged over the Peeler Ranch. San Miguel's expert witnesses have concluded that groundwater is infiltrating this ash-infused spoil and then seeping into and through adjacent Peeler land. Eric Matzner, San Miguel's expert, explained that his data indicates that water is flowing through the spoil on the Peeler Ranch and has been since at least 2004, that coal ash, spoil, and groundwater have mixed in Area A of the ranch, and that it is seeping into adjacent land outside of the lease boundary. Direct evidence of harm from the environmental pollutants which originated in the off-site origin coal ash that Kiewit has buried on the Peeler Ranch at Pit 10 has been documented on the Peeler Ranch. In areas receiving seepage from ramp Pit 10, San Miguel's consulting hydrologist observed vegetation stress that could be from elevated dissolved solids originating in coal ash. He described how pollution from the seepage alters the ranch's vegetation composition because the natural vegetation becomes stressed, but then you would get more salt tolerant plants coming in, which are not used for cattle grazing. These contaminants have been detected in water from the La Perita Creek floodplain on the ranch, which is where San Miguel discharges ash-infiltrated groundwater after diluting it. San Miguel's own hydrologist testified that the diminishing quality of the groundwater as seeps out of Pit 10 also impacts the ranch's surface water quality. San Miguel admits that the peeler ash is commingled with offsite ash, and according to San Miguel, the ash can no longer be separated by origin. Because Kiewit caused the ash from different origins to be mixed, the burden falls on them to delineate what injury was caused by which ash. To the extent that ash is now so confused as to render the mixture incapable of proper division according to the pre-existing rights of the parties, the loss must fall on the one who occasioned the mixture. That's from Humble Oil from 1974, Your Honor. Because it was Kiewit who commingled the ash, the burden is theirs, not the peelers, to distinguish the peeler ash from offsite origin ash. And to the extent that can't be done, Texas law makes San Miguel and Kiewit legally responsible for all the injury caused by the burial of that coal ash on the peeler ranch. Certainly does not impose on the peelers the burden to segregate which ash disposed by Kiewit caused which harm. And as Mr. Brown explains in his declaration, and Mr. Guthrie showed the court today, San Miguel had repeated complaints that Kiewit did not remove coal ash from the pile at the ranch, such that coal ash was allowed to fall into the stream beds that crossed the plant, another pathway for coal ash constituents to get into the groundwater and the surface water of the peeler ranch. So there's plenty of evidence to support a finding that Kiewit's actions are a substantial factor in bringing out the damage to the peeler ranch.
Your Honor, I'm sorry to interrupt, but we've gone way beyond arguing this motion about Mr. Brown. And just for the record, I completely disagree with Ms. Whittle's characterizations of what the record includes and doesn't include. What she just talked
Let's
about.
take these one at a time. So,
okay.
Your Honor, I'd like
Let's
to point
go.
out that these are all, I am responding to all of the new arguments that Mr. Guthrie made today for the first time that were not in his motion. And so to the court, to the extent the court wants to disregard all of those new arguments, I do not have to respond to them. But I can't allow him to make new arguments and then not respond. Mr. Guthrie keeps accusing us of bringing up new things, but today's argument was almost entirely new. None of the evidence he brought to the court today was in any motion. And so I should be allowed to respond. And I didn't interrupt Mr. Guthrie when he was going far afield.
Your Honor, I disagree with that. But again, the point is we're going way beyond the motion to disqualify Anthony Brown.
okay, well, I think we're getting close to being done. Go ahead, ma'am.
Your Honor, in its supplemental motion to exclude, Kiewit once again advances the argument that an exceedance of a state action level of a chemical of concern is required to maintain a claim against it. The peelers rely on arguments they have made in responses to the motions to exclude peeler experts Bowman, Sitton, and Ross, and of course the response for the motion for summary judgment on that same issue. To the extent the court concludes that the ecological risk assessment guidance issued by TCEQ must be followed as a matter of law to support a tort claim, we submit that what Mr. Brown did to delineate waste contamination from San Miguel's operations is consistent with that guidance. Although again, we do not concede that TCEQ's unenforceable agency guidance must be followed to establish a tort claim for real property damage under Texas law. So in sum, Your Honor, the peelers ask the court to deny the motions to exclude Anthony Brown in their entirety and admit his opinion testimony at trial. Thank you.
Give me just a moment. Let me look at my notes.
Your Honor, I'd like 5 minutes if possible when you're done.
Okay, all right. I had notes of things I wanted answered, but they've all been answered. So, Mr. Sutherland, go ahead.
Yeah. So just real quickly, Your Honor, San Miguel joined the motion to strike the late offered affidavits by Mr. Brown. So I'd just like to draw that to the court's attention. And obviously we're still, that would be something that we would ask the court to do. To the extent that the court denies that motion, we would like to incorporate these objections to Mr. Brown's testimony, anything that's within those affidavits as well. On the substance of Mrs. Whittle's response, it's their burden to prove causation, Your Honor. And so it's their burden to address alternative causes. And it's not our burden to go out there and have our experts go out there and do this. This is what they're supposed to do, and they did not do it. Just quickly going through the alternative causes, with respect to the impacts of natural salinity, you didn't hear anything from Mrs. Whittle about why Mr. Brown didn't go and look at those anions and cations that he had data for and analyze those in the exact same way that he analyzed the metals. So there's no expert testimony that goes to the background of what salt is based upon data that came from the Peeler Ranch. With respect to the artesian well, you heard Mrs. Whittle say that, well, he looked at the data from that well and he determined that none of the constituents of concern were in that well. Well, that well is 10,000 parts per million sodium chloride, Your Honor. It is full of salt. It's higher than what the TCEQ will allow San Miguel to discharge out of its Pond 7. And the idea that that salt is not a constituent of concern is inconsistent with the arguments that you've heard on multiple days on multiple topics about how this is the case about salt. And I'm really confused by the Peeler's arguments that Mr. Brown doesn't have any opinions about salt. They appear to want to have it both ways. They want to say all of his contamination is based upon his metals analysis, but then when they get to Mr. Johnson and when they get to Mr. Brown talking about contamination, we're cleaning up salt. And so, I think that if Mr. Brown doesn't have any opinions about salt, then the court needs to be clear and strike any opinions or make it clear that he's not allowed to give any opinions about salt. If he wants to talk about boron, that's a separate issue. Now, it's also clear from Mr. Brown's testimony that the only metal that he relied on is boron. And if you go back and you look at his deposition testimony, I won't pull it up because it would take a little bit more time, but if you go back and you look at page 110, lines 6 to 18, and 145, page 145, lines 14 to 146, line 2, he makes very clear that the only thing that he's relying on as far as metals goes is boron. And we showed that picture of what the boron area of contamination was, and it's much smaller than the pink line. And so if that's all he's relying on, that should be all that he can talk about. He stated in his deposition, sworn testimony, it's hard to confirm that there's clear pattern that associates those detections, that is detections of metals other than boron, with contamination from the power plant and the mining activities. That's his sworn testimony, Your Honor. With respect to oil and gas, just like your midnight dumping case that you were talking about, there's no report to the Railroad Commission of those releases. And the same thing is true for releases from oil and gas activities that happened prior to 1980. I'm not saying those are midnight dumpers, but there's just no requirement to report it. In all of these things, if you go back and you look at that picture I showed you early in the argument that showed all of the drainage pathways, all the blue on it, all of the contamination that the peelers are alleging follows through those drainage pathways, and they're common drainage pathways where it would also drain the oil and gas, any releases from oil and gas. And that's why these chemistry-based forensic techniques are so important to identifying the signature of the particular source where it came from, because they're all draining through the same place. And Brown didn't do any of that. A couple of things quickly. Ms. Whittle put up a diagram that showed where they're asking for remediation. She then told you that there is data supporting those areas of remediation, and that none of those areas are the areas that Mr. Brown has identified as possibly being contaminated. That's flat untrue. If you look at the south part, that there's like a little teardrop area at the very south part of that map, there's no data there. There's no data there, and Mr. Brown identifies that as possibly being contaminated. So that is just flat untrue, Your Honor. And let's see, what else? Oh, finally, you asked if there were any references in the record that this area used to be an inland sea. If you go and you look at Mr. Brown's original opinion, which was one of the exhibits to our motion to exclude on page 19, he describes the property that we're talking about as emerging in the late Paleozoic era. It was a shifting inland sea shoreline and southward, and it left evaporative deposits because of the hot arid climate. And evaporative deposits are, of course, salt. That's all I have, Your Honor.
Your Honor, I need a few minutes as well.
Go ahead, Mr. Guthrie.
I'm sorry. I'll be real brief. I need to respond to some of the representations that Ms. Whittle made to the court about things that KMG testified to or didn't testify to, because they were just flatly untrue. First of all, Ms. Whittle represented that in 2010, KMG constructed the land bridge. That would be kind of impossible given that KMG did not get to the project, did not get to the mine until January of 2011.
Your Honor, I said 2012, and if I didn't, that was an error. It was 2012.
She also said that there's testimony in the record or evidence in the record that KMG filled the dewatered pit with ash. We looked at the sections of the deposition testimony that Mr. Brown cited for that assertion. There was no record in there, or I will submit anywhere else, that said that KMG buried ash on the Peeler Ranch. She also represented that KMG's corporate representative testified that water runs off and distributes, and that then the water is distributed off the Peeler Ranch by design, or words to that effect. He said no such thing. And I defy her to show us where he said that, because he didn't. KMG does not distribute water off of the Peeler Ranch. It never did. It did not discharge water off the Peeler Ranch. It never has. It never did. She said something to the...
What definition are you using when you say off the Peeler Ranch? Are you saying that KMG has never discharged water onto the Peeler Ranch?
Let me restate that. I misspoke. KMG has never discharged water onto the Peeler Ranch that is outside of the mining lease or the buffer zone lease. Okay. It did limited discharges for dust control purposes on the Hall Road and the other roads on the Peeler Ranch that it operated on. But that was only when it was operating. We're talking about dust control water here. And all of those operations took place on the mining lease itself, within the mine permitted area. It never discharged.
Would the water, I mean, short of building a pipeline across the buffer lease, they could not have discharged water directly onto the Peeler Ranch. Did the water that was discharged flow across the buffer lease and go onto the remainder of the Peeler Ranch?
The only discharge from the plant site was for dust control purposes along the road that Kiewit Mining Group used, and that is all within the mine permitted area. It's subject to the mining lease. It never discharged any water, I think, as the court is describing it, from the plant site. Okay, other than for dust control purposes when its trucks were running up into the plant site. But there you're just talking about a sprinkling of water to wet the dirt road, so to speak. It never discharged in the sense of it pumped water out of an in pit on the Peeler Ranch or it pumped water out of a mining pond on the Peeler Ranch. Okay.
And hold on just a second here. I haven't signed that, right? All right. I'll get it to you just a moment. No, that's fine. Go ahead, sir.
It did not discharge water at all on the Peeler Ranch other than for dust control purposes in the areas on which it was operating, and that was principally on the Hall Road. But it also used dust control water when it was operating to place ash on the pile in pit 10. And all the water that it used is required by the permit to be contained within the mining permit area. And there's no evidence that it went outside the mining permit area, which is within the mining lease. Now, there's no evidence of toxins in this case migrating from the ash pile. No scientific evidence. Nobody traced toxins from the top of the ash pile or the middle of the ash pile or the bottom of the ash pile, either by land or into the water at in pit 10 through the groundwater for a half a mile and coming up outside of the mining lease area. And that's a significant part of our problem with Anthony Brown's conclusory opinions that are unreliable. He says it happened, but there is no proof that it happened. There was no scientific testing to determine that it happened. I disagree with Ms. Whittle's characterization of the commingling of the ash and the effect of the Humble Oil case, but that's really irrelevant here. That's an issue for another day. Let me respond to Ms. Whittle's characterization of my allegedly confusing statement that Mr. Brown did not delineate groundwater contamination. What I meant to say, and what I think I said was, he didn't do any scientific testing to delineate groundwater contamination. He's guessing at it. And there's a big difference there. And that's the issue that makes his opinions, to the extent they're used to establish causation against Kiewit Mining Group, unreliable. No scientific testing to confirm that any substance that you would call a contaminant migrated from where Kiewit Mining Group was operating based on something that Kiewit Mining Group did or didn't do to put it there or keep it there outside, to a place outside of the mining lease or the buffer zone lease. And I think I've got one more thing to say, and then I'll be done. Ms. Whittle said, if we would have pointed to the court to the plant and mine and said that they generally cause pollution, the court would or should pour us out. And I'll submit to you, Your Honor, that's exactly what they've done here. They pointed at sources that they think might cause contamination and attempted to manufacture this alleged contamination based on an exceedance of background levels. And they just assumed that a contaminant got from point A to point B. And that is bad science. That there are many techniques that can be used to trace, and this testimony by Brown, and we'll get to Johnson later, should not be admitted. It is unreliable and it is irrelevant as to any issue against KMG. Thank you.
All right. And Ms. Whittle, about the issue of whether the area of boron contamination is smaller than the pink line, the solid pink line?
So, Your Honor, I think that Mr. Sutherland has gotten some of my statements mixed up. Contamination by the peeler experts has been delineated based on both salts and metals. And the remediation that Mr. Johnson developed was based on salts in topsoil because that's the driver for cleanup. If we attempted to clean up everything, it would be prohibitively expensive and pretty much impossible. So when we say that salts are the driver of cleanup, that's what I mean. And San Miguel's own expert agrees with this. I mean, when they delineated the harm from or the contamination from the power plant, they looked at boron, lithium, mercury, radium, and found exceedances. But the cleanup was guided by topsoil parameter of electroconductivity. That's just the way this works. So I think Mr. Sutherland is confusing two different issues. And I guess the specific question about, so if you look at the electroconductivity map, it shows what we believe are exceedances of salts, which are very widespread. Then we went back and did soil sampling, and we were unable to complete soil sampling to go to the extent of all of those electroconductivity exceedances because it was prohibitively expensive and we didn't have the time to do it given the weather that we were facing at the period of time all of the investigation needed to be done. And so the extent of contiguous boron contamination is what Mr. Brown is able to say definitively comes from the San Miguel power plant and mine. And the larger extent of contamination with exceedances of other metals plus salts, which there isn't one parameter that's clearly contiguous for all of those points. He has delineated that as possibly contaminated, but our damage model is not based on the possible contamination. It is based on the cost of cleanup for the definitive areas.
Okay, all right.
Judge, just one very quick comment.
Yes,
I mean, I don't think I'm confused. And I would just ask for a little intellectual rigor here. And that is, if Mr. Brown is providing opinions regarding the extent of boron contamination, then let's limit his opinions to boron. And if Mr. Johnson is testifying as to whatever the salt areas are, and let's address those with Mr. Johnson. If Tony, I don't know if you can real quickly just pull up our exhibit number 11, and that will tell you where the boron is and the areas of remediation that that Ms. Whittle talked about. It'll be quite clear, particularly for the area to the south, that see that area of dashed pink line that was one of the remediation areas. That's not included in these yellow places where Mr. Brown has opined that there's boron contamination. And I would just suggest if the court does anything today, it should impose some rigor with respect to this sort of, find the opinion, because it seems to be moving around all over the place. And this seems to be the only thing that Mr. Brown is actually willing to stick with.
Your Honor, again, this is a completely new and different argument that Mr. Sutherland is making today. And so if the court is actually going to entertain this argument, then we should have time to respond with briefing because they didn't comply with the court-ordered scheduling order to raise this argument. For that area in the south that he pointed out, that's an area that has already had phase 3 bond release and yet continues to have scarring, and that there was a remedial action done under the orders of the Railroad Commission. And so, no, there isn't soil sampling in that area, but the electroconductivity is higher there, and there's a clear history of problems from coal ash wastewater that were stored in that pond 8, and so subject to, or pond 1, subject to previous Railroad Commission orders. And so that is what that area is about in terms of the remedial program for Mr. Johnson or Mr. Brown. And we can explain that, sorry, Mr. Johnson, we can explain that in the motion to exclude Mr. Johnson. But I urge the court not to issue some ruling based on, to limit Mr. Brown based on some new argument that was raised today that we haven't had the opportunity to brief and fully argue for the court, because this is completely new and different.
Sir, word search our brief for boron. It's in there.
That's
all right, Mr. Sutherland. If the peelers were asking for cleanup outside of the area that their expert are identifying as contaminated, I mean, that would be a very big issue. But if they're asking for cleanup or remediation in a smaller area, I mean, that might be a reason to suggest to the jury that there's a discrepancy in their evidence. But is that any cause to exclude it if they're giving the counter defendants a break?
I do, Your Honor, because that if they're allowed to present this evidence of this large pink line of the extent of all contamination, that's very prejudicial to my client, because then, you know, regardless of what they're asking for as far as remediation goes, they're asking the jury to accept as a factual matter that my client contaminated a bunch of property that's owned by the peelers that they did not contaminate. And that's a very, very, you know, that could influence how the jury reacts to these claims significantly. So yeah, absolutely. Absolutely.
They did contaminate it. We have plenty of proof to demonstrate that they did contaminate it. So,
all right. Anything else? Okay, we will see y'all in the morning.
Oh, what about the other motion? Are we going to try and do that late this afternoon or
on Mr. Johnson?
Mr. Johnson, it was scheduled for today.
Well, you'll also announce 3 hours, and it's been 4.
Yeah, I apologize. It took longer than I expected.
Yes, we'll take a break after the next hearing, and we'll start that. All right, Ms. Harkins.
I'm here, Your Honor.
All right, Ms. Hernandez.
Yes, sir.
Want to turn on your video? It's on.
What is my question? My question is about the visitation, child support, and when do I get my son back with me? Once I get everything together?
Okay, ma'am, all I know about this case is that it's set for hearing today. And there's a child involved, and that Ms. Harkins represents someone else who I assume is the child's father, but perhaps not. I have no other knowledge whatsoever about this case. I don't know who has legal custody now. I don't know if there's a change is being requested. I don't know any of that. So I can't tell you anything like that.
Do I get a hold of a caseworker to figure some things out?
Well, no, ma'am, because it's
my go-to
right now.
on your right.
Let me finish. All right. So is this something that you want to have a chance to go back to the breakout room and speak with Ms. Harkins about and see if you can work something out, or do I just need to ask her to?
Yeah,
tell me-
I want to talk to as many as people as possible right as of right now, so I can know what I could do on my goal to get my son back.
Well, all right, now, Ms. Harkins is not your attorney, and you and her, or the attorney, Ms. Reed, from the Attorney General's office, speak that they're not going to be giving you advice. Now, they may offer you some options, but they're not going to be giving you advice on what you can do because they're not
They're
sure.
against- right. All right, Judge. I didn't sign over my rights. I have my parental rights because I'm the mother, and I was wondering, like, how do you say it? What I want to do here is I have my dad's land here. My dad's still, like, you know what I mean? I gotta
All
do
right,
that.
and ma'am, I've got to tell you that I don't know at all what this case is about. I don't know if Ms. Harkins is asking to terminate your parental rights. I don't know if she's asking just that her client gets more visitation with the child and the child stays with you. I don't know what's going on. All I know about this case is that it's on my docket and it involves a child. So if you want to try and work something out, you're going to need to speak with Ms. Harkins and Ms. Reed. If
Okay.
you,
I would like to speak
otherwise,
with
we're going to start the hearing in just a moment. So do you want an opportunity to speak with them and see if you can come to an agreement, or do you want to just
To
go
speak
ahead and
with
start
them.
the hearing? I can't hear you.
to speak with them to see if what they could do or what could we do to work things out.
Okay, so let me open up a breakout room again, and I will assign you and Ms. Reed and Ms. Harkins to a breakout room.
Judge, I did let the CPS caseworker know to go ahead and get on. So her name is Yvette Novato. If someone's trying to get on, that's who that is.
Okay, and no one's trying to get on right yet. So I've given you a breakout room to open up, and
I'm there now, Judge.
with the attorneys on the other side, on the Peeler case, I'm going to go and look at that other motion.
Yes, Your Honor.
Your Honor, is there a time you would like for us to be back?
We'll just hang out. I don't know if we're going to need this hearing or not. We'll find out pretty shortly, I guess.
Okay.
But I mean, okay, so I have already opened up the Johnson and Brown. I just skipped over the parts that said they were just for Johnson. So let me go back.
Judge, this is Jennifer Friel.
Yes, ma'am.
Mr. Guthrie saw the email, but I think the parties are fine moving Johnson to tomorrow. If that's what you would prefer. I know the calendar, the afternoon's
Okay.
indicated. It's up to you, really.
It doesn't matter to me if I need to take I told the family law case they could go next, but I told you I have a hard drive away time of 2 p.m. tomorrow. So, and I think the dockets are more extensive on my other stuff. So it would be better if we can get this knocked out today.
Understand. Thank you.
All right, Ms. Navarro? This is Judge Wilson.
Yes, this is Yvette Navarro.
All right. Yes, ma'am. The attorneys, Ms. Harkins, Ms. Reed, are conferring with Ms. Rodriguez. Or anyhow, they're conferring with the mother. If you want to just remain here for a while, you can, or I'm not sure how good the contact information or contact access they have with you. So they're conferring. I'm not going to give them an extended period of time to do that, but I'm going to give them at least 10 or 15 minutes.
Okay.
So that's your choice. Either hang out or you can dial back in if they call you, if they have cell phone number or some other way they can reach you immediately.
I can wait. It's not a problem.
All right. Thank you.
Mhm.
All right. Where do we stand?
Judge, we conferred and we do not have an agreement, so we still need a hearing.
Okay.
I don't see Ms. Hernandez back.
Okay. She's still in the breakout room. I'll close it. And let me sign on to LGS.
There she is, Judge.
All right. Okay, so are both sides ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, so what is the current status of this case?
Judge, the SAPSR was filed in 2016. There are no orders currently in place. It's my understanding that everything came to a standstill. CPS had gotten involved. So my client filed an intervention in April of 2020. seeking primary conservatorship. And excuse me, we're here to have the merits on that petition today.
Okay, and who is your client?
Judge, my client is the paternal grandmother, Lucy Aweto, and she is there. She's at my office, and her son is Felix or Feliciano Rodriguez, and he's here at my office as well.
All right, so let me make sure I have all the parties written down. Lucy Aweto, Felix Hernandez.
It's actually Feliciano Rodriguez
Feliciano. I'm sorry.
the third. He goes by Felix.
All right, Miss Hernandez?
Yes, sir.
Okay, and I'm sorry, your first name is Victoria?
Veronica Alyssa Hernandez, the mother of Michael Luke Rodriguez.
Okay, ma'am, I keep hearing words. Are you trying to address me?
No, I'm telling you, Veronica Alyssa Hernandez,
Okay, but
And,
before that, I kept hearing,
mother of Michael Luke Rodriguez.
I kept hearing words I could not understand. So I'm going to ask you if you wish to, there'll be times when I call on you, and if you wish to speak and because you have a question or because you have an objection, then by all means speak up, and I'll deal with that as appropriate. But otherwise, don't just be making indistinct noises in the background, okay? Okay?
Yes, sir.
All right. All right, and you also have Yvette Navarro as a witness? Ms. Harkins?
Judge, I'm sorry, you cut out.
Okay, I think you cut out because your picture froze, but all right, you also have Yvette Navarro as a witness?
Yes, Your Honor.
And Ms. Reed, what part do you have here with the AG's office?
Your Honor, our office actually was the original petitioners in this case. Back in 2016, we filed in 40 court. Our petition was moved up to district court based on the request of Ms. Hernandez's attorney at the time, Mr. Richardson, who has since withdrawn. It stalled here as Ms. Harkins has already stated, and Ms. Harkins intervened into our OAG proceedings.
Okay, so other than wanting guideline child support to be paid, does the Attorney General have an interest in this case?
No, Your Honor. I do believe that the testimony will show that neither parent currently has private health insurance, but the child is receiving government medical assistance, and so we would like that delineated in the order as well. Additionally, I do believe that Mr. Rodriguez, we did do genetic testing in the case as ordered in the 4D court that shows, and it does show Mr. Rodriguez is the father of the minor child. So we do need a formal adjudication of parentage between Mr. Rodriguez and the child.
What does that mean?
Right, ma'am, what that means is that because you were not married to Mr. Rodriguez whenever the child was born, the law.
It's not even on the birth certificate either. Sorry.
Okay, ma'am, you ask a question, I'm trying to explain something to you. So I will ask you to not keep interrupting. Because you were not married to Mr. Rodriguez, or were you married to anyone else when the child was born?
No.
Okay, the child does not have a presumed father. Because the DNA test shows that there's like 999 million out of a 999 million and one chances that Mr. Rodriguez is the father, then I will sign an order finding that he is the father. Okay? All right, so let me ask all of the potential witnesses to raise their right hands. I need to get Ms. Harkins where your witnesses are. I'm asking them to unmute. That's Ms. Aguero, Mr. Rodriguez.
Ms. Navarro.
Would you remove your hat?
Mr. Rodriguez.
Okay, so, and I'm going to ask Ms. Navarro to start her video so I can swear everyone in at once. All right, I will need Veronica Hernandez, Feliciano Rodriguez, Lucy Aguero and Yvette Navarro to raise your right hands, please. All right. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Is that a yes, Ms. Hernandez?
Yes.
Okay. All right. You can put your hands down. Thank you. All right. Go ahead, Ms. Harkins.
Thank you, Your Honor. At this time, I'd like to call Yvette Novato.
Go ahead.
Are you Yvette Novato?
Yes.
And do you currently work for the Texas Department of Family and Protective Services, particularly Child Protective Services?
Yes, ma'am.
And how long have you worked for them?
I've worked for the department since October of 2016.
And what is your job there?
I'm a caseworker with family-based services.
And are you familiar with the family of Micah Luke Rodriguez?
Yes.
And is Micah currently 7 years old?
Yes.
And in particular, are you familiar with his mother, Veronica Hernandez?
Yes.
And until recently, does she have an open case with the department?
That's correct.
And what is her history like with the department?
She has several CPS cases that she's previously been involved with.
And was the most recent one opened in November of 2018?
The most recent was opened on March 20th of 2020.
Yes. Okay. So was there one before that was open in November of 2018?
Yes.
And was that one closed in February of 2020?
In March 18th of 2020.
Okay. It's closed in March of 2020 and was a new one opened in the same month?
Yes.
Now, for the November 2018 case, was Micah placed with my client, Lucy Awedo?
Yes.
And in the March 2020 case, was Micah placed with Lucy Awedo?
Yes.
And what are the department's concerns about Ms. Hernandez?
The current concerns right now is her mental health and substance abuse use.
And what is the substance or substances that the concern is that she's using?
Meth.
And in the most recent case from March of 2020, was Ms. Hernandez cooperative in working services and taking drug tests?
She was in partial compliance.
What did she not comply with?
Let me pull up the history so I can review it.
Thank you.
Because when she had her case in March, I wasn't the caseworker, but I have access to that case information, so I can review it as well. I just had my case information available and open.
Was that the case from 2018 to March of 2020?
Yes, that's correct.
Do you recall the reason for the latest case last March being opened up?
The last case that was opened up in March of 2020?
Yes.
Yes, the reason that CPS became involved was because Ms. Hernandez threw lemon pills at Micah, and she caused physical abuse. She left marks on his face. And so law enforcement was involved. They were contacted, and she was arrested.
I was sitting in the back of a cop car when that happened, and that was me.
Ma'am, I will give you an opportunity to ask questions of this witness later. And even when you have an opportunity to ask questions of this witness, that will not be a time for you to testify. I will give you an opportunity to testify after the attorneys have had a chance to speak with this witness and call their other witnesses. You are the respondent, meaning that you can call witnesses yourself or you can testify yourself. but this is not a time for you to testify. It's a time, if you need to make a legal objection to testimony, you may do so. All right, go ahead, Ms. Navarro.
I think you had finished answering that. So with these recent cases, have there been concerns about Ms. Hernandez being at times a transient person?
Yes.
To your knowledge, does she usually have a stable home environment?
No.
Have there been concerns about domestic violence in her home in the past?
Yes.
And we've already addressed the concerns about drug use. Do you know of any mental health issues specifically that are a concern?
No, I tried to set up evaluations for her through our clinical psychologist, and she did not make that appointment.
Has she historically cooperated with services that are asked of her to
No.
complete?
No.
Is she historically cooperative with taking drug tests that are requested?
No.
At this time, is there an open CPS case involving Micah or Ms. Hernandez?
Yes.
And is that in the process or is that on hold?
It's in the process.
And is part of that process to resolve this private action that's pending now?
Yes.
Do you have any concerns about Lucy Oweto's home?
No.
Do you feel that it is safe for Micah to be in Veronica Hernandez's home or possession unsupervised?
Can you repeat the question again?
Do you have any concerns about Micah being in Ms. Hernandez's possession unsupervised?
Yes.
And do you think that that is in his best interest to be with her unsupervised at this time?
No.
And at this time, does the department have any case open with the father, Feliciano Rodriguez?
Yes.
And are there any concerns that the department has with him having any unsupervised visits with Micah?
Yes.
So what is the department's recommendation on what kind of visitation Micah should have with both of these parents?
Supervised contact.
Judge, I'll pass the witness.
Bree, do you have any questions for this witness?
No, sir.
Okay, Ms. Hernandez, I again will tell you that this is not a time for you to testify. This is by that I mean it's not a time for you to say I did this, I did that, or I didn't do something. This is a time for you to ask questions of this witness. So, what questions do you have for Ms. Navarro?
Can I get a new caseworker?
Okay, no. So, what questions do you have for Ms. Navarro about her testimony or about anything else you think I need to hear to make a decision about who Micah is going to be with?
Because I know her last name's Navarro. There was a Navarro around here that was kind of scaring me just because I wanted to get a new caseworker. So I kind of want a new caseworker.
All right, ma'am, I'm not
I mean, he
CPS,
stepped on my property.
district judge. I'm not CPS, I'm the district judge. So do you have questions for this CPS caseworker, Ms. Navarro?
I guess I'll talk to her about it, right? Or the Department of CPS?
Ma'am, I just want to know if you have questions for this case that you're in the middle of on the custody of your child.
I have no questions. So just my question is there a chance to reschedule another?
No, ma'am, we're going to proceed on this afternoon. We've already begun.
Alrighty.
So what other witnesses do you have, Ms. Harkins?
Judge, I am finished with Ms. Novato, and at this time I'll call my client Lucy Oweto.
All right, Ms. Navarro, then may she be released?
Yes, Your Honor.
All right, thank you. You are released, ma'am.
Thank you, Ms. Novato.
Thank you.
Go ahead, Ms. Harkins.
Thank you, Your Honor. I'll call my client Lucy Oweto. Judge, she is hard of hearing. So Ms. Oweto, can you hear me?
Yes.
Okay. Are you Lucy Oweto?
Yes.
And are you the paternal grandmother of Micah Luke Rodriguez?
Yes.
And has Micah been in your care since November of 2018?
Yes.
Now, is it your understanding, or do you agree with Ms. Novato, who testified that that lengthy CPS case was closed in March of 2020?
Yes.
And at that time, where did Micah go?
With me.
Well, when they closed the case, did he stay with you or did he go with Ms. Hernandez?
Oh, when they closed the case, he went with his mom, and then they were gone for a week. They came back for vacation.
They left for a vacation?
Yes.
One visit. She takes my son.
Hey, ma'am, I've told you before, and it's the same with this witness, you will have an opportunity to testify shortly. If you
Okay.
have a legal objection, you can make that, but you are not to interrupt, just to interrupt. You can ask questions of this witness in a few moments if you want to. Go ahead, Ms. Harkins.
Thank you, Your Honor. Okay, Ms. Oweto, you heard testimony from Ms. Novato that another CPS case was opened in March of 2020. Is that correct?
Yes.
And did you witness the incident between Ms. Hernandez and Micah that led to that case opening up?
Yes.
And can you tell the judge what happened at that time?
Michael wanted to get your attention, and she was upset about, I don't know, she was upset, and she threw him some lines and hit him in the face, and Micah started crying and ran outside.
And was she arrested for that?
Yes.
Do you know, did that case get closed? Did that criminal case get no billed by the grand jury, or is it closed to your knowledge?
The what?
Did that criminal case get closed?
Yes.
Okay, so she did not do any kind of probation for that matter, is that right?
I don't think so.
Now, at that time, did CPS replace Micah in your home?
Yes.
Let's talk about your history with Ms. Hernandez. Did Ms. Hernandez ever live with you in the past?
Yes.
When did she stop living with you?
Well, she would stay there, but then she would leave. She'd come back and forth. The last time when they came for that week, she left as soon as she got there. And I didn't see her till she came back that day with the lines. And then after she got arrested, she wasn't allowed to stay there no more. She kept wanting to stay there. She kept wanting to come back to the house, and I told her she couldn't.
Well, when that CPS case was opened in November of 2018, did she reside there or stay there at that time?
Sometimes she stayed with me. Sometimes she stayed, I don't know where. Sometimes she stayed with her brother and her sister-in-law. She came and went.
She came and went. Okay. At that time, were you supervising her visits with Micah?
Yes.
And since you've lived with her in the past, what concerns do you have about her drug use?
Many. It's because she'll go off and she'll scream at me. She'll tell me stuff, and I don't want to say nothing because of Micah. But he has gotten into it with her. He has told her before that you're embarrassing me. You need to leave the house. I mean, stuff like that. And it's just, sometimes it's been she's real vocal. She starts screaming, yelling, not to talk to her and stuff like that. And when she comes, the people she hangs around with, the ones she still hangs around with, it's not, it's not good.
Do you believe that you've seen her under the influence of drugs in the past?
The what?
Do you believe that you've seen her when she's high in the past?
When she's been under the influence of drugs, have you seen her?
No. If I've seen her do drugs?
No.
No.
Have you seen her under the influence of it?
Oh, yes, yes. She'll like mumble. I'll go, you need to speak up. And she always wears her jacket, her hood, and you just hear mumbling. And then she goes, nothing. I wasn't saying nothing. And then a lot of stuff you can't understand. I know I'm hard of hearing, but there's some stuff she would just walk off, start talking, and take off walking. So.
And what kind of drugs do you believe that she's been using in the past?
Marijuana and meth.
And do you have any idea if she's using drugs at this time? Not necessarily right now, but at this time.
To me, it seems like it, but I don't know.
What is it about her behavior that makes you feel that way?
Well, the way she is, because she just lives not even a block from me. And I seen where she's at. They have no water, no light, and all the people that are living there, they're all drug users, the people she hangs around with, and that's bad. It's bad.
Whose house is that?
The what?
Whose house is it that she's staying at?
It's her dad's, but word was her sister-in-law told me that they kicked them out. The sister and the brother, all these people moved in, and supposedly she's staying there, but her dad's not living there. He moved in with his sister.
Okay, so we've established that she was arrested last March. Was she arrested for injury to a child?
Yes.
Okay, has she been arrested for other things?
She's been, when she's been under the influence, she was arrested also in Pleasanton for under the influence, and the caseworker at that time had told her to get in the ambulance, and she didn't want to, so they arrested her. She's been, she's called me before that to go pick her up. She's fighting with her boyfriend at the time, Gino Hernandez, and she's going off. She got arrested. I know she's been arrested about 4 times. I mean, it's been for the thing I guess she's under the influence. She wants to argue with the cops and stuff like that. She just.
Okay, since you filed your intervention in April of last year, how often has Ms. Hernandez been seeing Micah?
She would come like, cause she's on food stamps, and she would, I tell her, I go, he's got food. She would go, no, I need to give you food because I'm supposed to. She would come once a month. And I told her, you can't be coming over here. When she had gotten out of jail, and she would come through the back window and start banging on the window, and she'd stick things through where the AC unit is at. She'd move the little thing and stick stuff in there. And she would talk to Micah through there. So it wasn't really, maybe she came maybe once, twice a month.
Okay.
But when she found out that we were gonna start going to court, she wanted to be there all the time. She wanted to talk to him on that whatever.
Oh, FaceTime?
Yes.
Okay, she was trying to FaceTime with him?
Yes.
Okay, had she been doing that?
He was busy and he wouldn't talk that long.
Okay. What is Micah's behavior like, or how does he act around her?
How does he act without her?
Around her.
No, around her.
I mean, he loves his mom, but he don't last that long to play with her. Like, you know, he wants to be running around and everything. He does love his mom, but that, you know, she tells him something, he kind of looks at me, but I won't ask him, what did she say? So, you know.
And has she ever given you money or brought anything? You know, you said she brought food. Has she ever brought anything or given you money for Micah?
Like when school started, she got him some jeans and some warm-up pants and 2 shirts. And she bought him some shoes. She bought him socks and washcloths, but they were like baby. Like for babies, they didn't fit him. She bought some, you know, like pencils, string of binder, stuff like that.
So she's provided some things, right?
Yes, this was before school started.
And do you feel that if Micah were to go with Ms. Hernandez unsupervised, that could impair his physical or mental well-being?
Yes.
Do you feel that her visits should be supervised?
What?
Should her visits be supervised?
Should her visits be supervised?
Yeah.
And are you asking the judge to order for her to have the visits on the first and third weekend of the month, on Saturday from 1 to 3 and Sunday from 1 to 3?
Yes.
And are you asking that those be supervised by you or another adult that you designate?
Yes.
And are you also agreeable to her having supervised visits every Thursday from 6 to 8 p.m.?
Yes.
And are you asking that, I should have started with this, are you asking that you be named the primary joint managing conservator over Micah?
Yes.
And are you asking for the exclusive right to designate Micah's residence and receive child support and make educational decisions for him?
Yes.
And are you asking that Ms. Hernandez be ordered to pay child support based on her current income?
Yes.
And is Micah on Medicaid?
Yes.
And is that in Ms. Hernandez's name?
Yes.
Now let's talk about your son. Where is your son currently living?
The what?
Where is your son currently living?
Where's my son currently living?
Yes, where does he live?
Where?
Well, at the house right now.
With you. He lives with you, right?
Yes. Oh, I'm sorry. Yes, he lives with me.
And how long has he lived with you?
How long?
Yeah, Lucy, can you hear me or not?
The what?
How long has your son lived with you?
Couple of months now. Couple of months.
Okay. And now, did you hear Ms. Novato say that the department feels that his visits should be supervised at this time?
Okay.
And so are you agreeable to his visits being supervised at the same times and days that Ms. Hernandez's are, but on the second and fourth weekend?
Yes.
And are you asking that the judge reserve the fifth weekend for you to have a weekend with Micah?
Okay. Yes.
Is that what you're wanting, Lucy?
Yes.
Okay. And are you asking that your son pay child support at minimum wage because he does not currently have a job?
Yes.
Okay. Judge, I'll pass the witness.
Ms. Reed, anything?
No, I don't have any other questions for Ms. Aguero.
Okay. All right, Ms. Hernandez, again, you'll have a chance to testify on your own behalf shortly. Do you have any questions for this witness right now?
Just waiting for my testifying. Just waiting to testify.
Okay, all right. Your next witness, Ms. Harkins?
Yes, Your Honor. At this time, I'll call Feliciano Rodriguez III.
Go ahead.
Thank you. Judge, I just need a sip of water. I feel like I'm screaming here. 1 second. Okay. Mr. Rodriguez, are you the father of Micah Luke Rodriguez?
Yes.
And are you in agreement with what your mother just testified to as far as conservatorship, visitation, and child support?
Yes.
And are you currently employed?
No.
When did you become unemployed?
Around October.
So are you agreeable to paying the minimum wage child support?
Yes.
Judge, pass the witness.
Ms. Reed?
Mr. Rodriguez, do you have any other children other than Micah under 18?
Yes, I have a daughter.
Okay. So and how old is your daughter?
She is 5.
Okay. And does she live with you or does she live with another person?
She lives with her mother.
Okay. And is there a court order in place for you to pay child support to her mother?
Yes.
I have no further questions.
Okay. Ms. Hernandez, do you have any questions for this witness?
No,
I can't hear you, ma'am.
no, sir.
Okay. Ms. Harkins, anything else?
Yes, Your Honor. At this time, I'll call Veronica Hernandez.
All right. Ms. Hernandez, you will have a chance to testify on your own behalf in a moment. Ms. Harkins has some questions for you first. Before Ms. Harkins begins, I need to tell you that from the behavior that I've heard from other witnesses, you may be asked questions that might tend to show that you had committed a crime. For instance, it is a felony offense to possess methamphetamine here in Texas. And if you're asked about whether you have been using amphetamine or possessing amphetamine and using it recently, that would be a question that would be asking you whether you have committed a felony, which is a crime, and your response to that might show that you've committed a crime. You do not have to answer that question, okay? You have a right against self-incrimination, meaning you have the right not to answer questions that might tend to show that you have committed a crime. I can tell you a couple of things, though. One is that because this is a civil case and not a criminal case, if you decide not to answer those questions, I could decide that the reason you don't want to answer those questions about whether you've committed a crime is because you actually did. In a criminal case, if a person doesn't want to testify, they can't be made to testify, and the judge or the jury can't hold that against them at all. That is not the case in a civil trial, which is what you're in right now. The other thing I need to tell you is that you have to either decide that you wish to answer questions that might show you've committed a crime, or you have to decide to give up your right to not answer those questions. By that I mean you can't answer a few questions that might show you committed a crime and then decide, well, you want to assert your right not to answer those questions. So do you understand that?
I don't know.
Okay. Let me say
I
again.
don't do no drugs because.
Okay, I'm not asking you about that. I'm going to tell you not to answer any, not to give you.
Okay. No problem.
I'm just telling you, if you are asked a question such as, whether you possess methamphetamine right now or something like that, if you're asked a question that might show you've committed a crime, you do not have to answer it. You understand that?
I understand.
Okay. If you do answer that question, then we go on the answer. If you decide you don't want to answer that question, I could decide that the reason you don't want to answer that question is because you actually do possess methamphetamine now. And that's because this is a civil case. If this was a criminal case, I or the jury could not do that. We couldn't consider at all the fact that you didn't want to answer questions that might show you've committed a crime. You understand that?
Hey.
Is that a yes or a no, ma'am?
I have no clue because I don't understand none of that.
Okay.
No.
Do you understand you have the right not to answer a question that shows you've committed a crime?
The show that I don't know. That's old stuff. I used to smoke weed. I don't know.
Okay, ma'am, I'm going to order the reporter to strike that response. I'm not asking you if you're committing a crime. I'm just telling you, if you are asked a question by Ms. Harkins that might show you've committed a crime, you do not have to answer it. Do you understand that?
That's out of my book. No, I don't commit no crimes. Not like that.
Okay, ma'am. And you understand that you don't have to answer any questions about whether you've committed a crime.
That's evil.
Okay, but you understand you don't have to answer questions about.
Okay, I don't have to answer that. I'll just tell her that the judge said I don't have to.
Okay.
Right.
That's fine. And you understand that I might decide if you don't answer the questions that you didn't answer them because you did commit a crime. Do you understand that?
Yeah, I didn't, and I don't have to answer that. Exactly.
But you understand that I might decide that the reason you don't want to answer is because you actually did it. Do you understand that?
I'm saying I didn't commit the crime or do a crime or I don't
Well,
know
if you refuse to answer the question.
I'm confused.
Okay.
Judge,
All right, Ms. Harkins, I'm going to order you to let you proceed, but
Crime is a very serious word. And it's just
I'm going
like,
to instruct you to not ask Ms. Hernandez any questions that might tend to show she's committed a crime, because in the answer of an affirmative knowing waiver of her right against self-incrimination, I'm not going to allow those questions. Go ahead, ma'am.
I understand, Judge. Thank you. Ms. Hernandez, do you agree with me that a CPS case was opened in November of 2018?
2018, when my mother died, yeah.
And do you agree with me that Micah was placed with Lucy Oweto from November of 2018 until the beginning of March 2020?
Beginning of March 2020. The beginning of March 2020. Okay, let me see here. 2018, my mother died. I was around a bad influence.
Okay, Ms. Hernandez, I'm not asking you about that. Do you
Okay.
agree with me that the CPS case was closed in March, the beginning of March last year?
Yeah, the whole time through that, the March 2018, my mother died. The whole situation there was me trying to get my life together. And then, let me see. I had a lawyer there ready, but we couldn't get a hold of Felix or, to do this, what we're doing to me, right? What y'all are doing to me right now. You know what I mean?
So can you tell us where you're currently living? What is your address?
I'm living here on 1106, my dad's house, 1106 Willow Street.
What street?
1106 Willow.
Willow. And how long have you lived there?
About 2 months. 2 months.
Who all lives there with you?
My Aunt Pauline and her kids, and my brother Greg.
Where did you live before that?
Before that, I was staying at my grandma's in my grandmother's car. I was staying at my grandma's.
How were you at your grandma's?
I came over here to check on my brother and everything and try to put a better home here.
How long were you at your grandma's?
About 2 or 3 months, I think. I don't know.
Where did you live before that?
Before that, I had from March 2020 through, may I just speak my time span and y'all are willing to listen?
All right, Ms. Hernandez, you'll have an opportunity to testify in just a few minutes. Right
Okay.
now, you need to answer Ms. Harkins' questions.
Okay, now I get that. Okay, let me see.
I had asked where you lived before you lived at your grandma's.
Before I lived at my grandma's, I was staying at my brother's house in San Antonio.
How long were you there?
About between the months, I guess.
Say that again?
Like in the months, like a month's end, I guess. I don't know how to say it.
For a month?
No, a little bit longer than that.
Okay, and are you currently employed?
Yes, I'm employed right now.
And where are you working?
Sleeping.
And how many hours a week do you work?
About 30 to 40 hours.
And how much do you make an hour?
$8.50 an hour.
Do you have any other children besides Micah?
Just Micah.
And you heard testimony from Lucy that she's asking to be named the primary joint managing conservator. Are you in agreement to that or no?
Well, temporary until I get things going here on my dad's land, like put a different home and fix the pipeline and everything. And also
Is there
have it.
running water at that house?
Huh? No.
Is there running water at your house?
No, there's no running water. There's light. My brother's girlfriend pays the light. But yeah, my aunt's been cleaning up around here, and I'm over here like working to pay for the plumbing.
What do you do for taking a shower and going to the bathroom and stuff?
Well, that's my struggle. I struggle. Let me see. I usually go everywhere. Like sometimes I use my work. I go to work. I take a shower there, and then sometimes I go to public stores. I clean my bird bath, and then that's about it, I guess.
Okay.
I'm trying to.
How long have you worked at Sleep Inn?
Sleep in. Let's see. About a month, half a month. Beginning about a month. No. I got 2 checks. My 3rd check is coming this week, so about 2 weeks span. So it's 2, 4, 6 months, 6 weeks.
Okay. Judge, I'll pass witness.
Read.
Ms. Hernandez, where did you work prior to working at the Sleep Inn?
Before that, I worked at Aaron's Pizza.
And how long did you work there?
About a month. I was trying to look for a good job. And then I found a good job, and I'm keeping that one that I have now.
And where did you work before you worked at Aaron's Pizza?
Aaron's Pizza. Before Aaron's Pizza, I worked at hold on. I need a moment. Where did I work here? There's Aaron's Pizza. Subway.
How long did you work at Subway?
A day, because I'm a small town. A lot of people like to bully, pick on me and stuff, and I just keep going forward. I don't know. It's a small town.
Okay. What's the longest job that you've had? The longest time you've worked at a job?
It was at Valero for about 3 or 4 months when I met my bad influence.
Okay. And when did you work at Valero?
2014.
In 2014? I have no further questions for this witness.
I got pregnant. Or I realized I was pregnant. I went straight to work.
All right, Ms. Hernandez, I've been telling you that you would have an opportunity to testify on your own behalf, and this is that opportunity. This is a chance for you to tell me what you want me to know and for what want me to consider. So go ahead, ma'am.
Okay. See, March 2018. Okay, March 2018. Let me see. March 2018. Let's start with Valero. I used to work at Valero. I had met a bad influence who showed me marijuana. I was a mom. I was working periods of time. And then I left the bad influence. And the house, I moved here, the house wasn't livable. And so I went to the grandmother. And at that time, my mother was sick. Whenever I moved to ask for the grandmother for help, she was sick, and then she passed away, right? So I went through a meltdown because that's my mom. And my mom's my everything. So I went through a meltdown, and I looked crazy, but it was just it scared me, death. And so everybody thought, I guess I was on drugs, but I don't know. And remember the bad influence, and you can't sleep around bad influences. If they make you look like a bad influence and make you, you know what I mean?
Yes, ma'am.
And so I was there, then I looked bad, and then my brother comes in, he helps me. He takes me to San Antonio to live in San Antonio. I go live in San Antonio while Micah was here with Lucy, right? And then I go to work. I work 2 jobs, make a good enough amount of money. I bought my son a bunch of stuff. I took Lucy out to eat. I took care of both of them, Lucy and Micah. You know what I mean? And then when that happened, I came here. They said the bad influence started here, right? But this is my dad's home, so I came to see what's up with people here because they're bad influences, just trying to figure, hey, like shoot, yeah, I gotta go. You know what I mean? And so it's like a motherly meltdown. You know, it's like a panic mother, like, oh no, I gotta do some things, I gotta figure some stuff out because I was only 18 when I had my son. I'm young, you know, and right now I'm 26, 27. So anyways, I'm trying to figure all this out, like trying to have my son in a good stage home, get rid of the bad influences, fix the home, plumbing, everything, you know? And then I didn't kick my dad out, or none of us kicked my dad out. My dad's also like saying like, hey, can you help me, mija? I need something to figure something out. There's bad influences here. I'm like, Dad, I got like a bad influence over there. Bad influences here trying to figure this out, you know? So I'm trying that, hold on. And then my son's over there, like I left over there and he was like, Mom, can you help me? Like I looked, but I was like a whole mind thought train, you know? I think, trying to figure out what's best for my son and my dad. And I looked confused, I looked a little lost, but I got it. And it comes to this day, you know? And now, CPS case was closed. My brother Michael, he steps in, he picks me up, we go sign Mike out of school, and Lucy was like, okay, that's fine, it's all right, you know? So I was like, yay. So whenever I was living over there at Lucy's, at my brother's place, that was a good opportunity to get a housing and get everything, you know? So I was like, yes, there's a good opportunity there. But the mother-in-law, my brother's wife, goes, y'all want to come visit, right? But she tells me with a warning, be careful, be careful. So I'm like, still like figuring stuff out. I'm worried about my dad because he's around bad influences. So I come over here whenever I came to visit, when Lucy said that I came for a vacation. Well, it wasn't a vacation. I came to visit for like 1 day whenever I had my son with me. So anyways, I come to visit, I let them visit Lucy and Micah, right? And then I come check out this place over here, like what's going on over here, you know, at my dad's. And then while I'm doing that, I'm trying to get food for my son at the same time. But this was when the coronavirus started too. And then so I'm trying to get food for my son and see what's going on here and figure out where's my dad at. But I know Lucy and them, I gave them their time to spend time with each other while I'm over here doing my motherly things over here, you know? And then I told my son, I'll be back, okay? I'll be back, I promise. He's like, okay, I come back. When I go back, Micah goes over there to Lucy on his own, right? And he comes back and he's like, Mom, I'm gonna go stay at Stephanie's or something like that. And I was like, I was busy trying to figure everything out. Sometimes when you think so much, you get blank or you get blinded to some certain things, you know? And so I tell him, he wanted me to go, but I was like, I can't go there. So I'm over here trying to figure things out here, but I don't want to go over there because you know how Lucy is too, you know? She starts problems. Over there at Stephanie's house, they have 3 boys and her, Stephanie. So I didn't want no problems. I just was trying to secretly figure things out on the low and also get out of Lucy's house as fast as I can to go back to San Antonio to start a better life, you know? And anyways, Micah says that he's gonna leave to Stephanie's. She goes, drops him off. Whenever she drops him off or something like that, I was over here trying to help Greg, my brother Greg, and everything, is trying to tell them to leave, but nope, nothing happened. And then I come back over there. I go back over there. When I go back, I finish, like I get brain tired over here. So I go over there to Lucy's, and then I was like, it was the next day. I didn't take days, periods, you know? The next day I go over there to Lucy's and I go, where's Micah? He's not here. He's not here. And I'm like, she knew that I was like think like thought blocked, you know, like writer's block. And so she starts saying that, I said, well, anyways, I kept asking her, where's my son? Can you bring him? Can you bring him? No. Like she starts saying that. Well, I was like, okay, well then I'm gonna sit here, take a shower and wait for him to come back. She had him over there at Stephanie's. And then, so I sit there, I wait there. After I take a shower, I lay on the couch, getting ready just to go to sleep and just wait and think on my thought, you know? Well, I sleep on it, you know? And then whenever I go there, she goes, you need to leave. She's trying to mess up my thought block and tells me, hey, you gotta go. So I'm like, I don't wanna stay with these bad influences because they're just driving me nuts. And so I had to go to the bad influence from the get-go that showed me weed. He took me in, let me stay there. And like, I was already frustrated and tired. And so I go over there and then I go back to the house because Lucy told me to leave. And then I go back to Lucy's house with food. And once I had to pretty much bring food to just stay there in a way. So I'll go stay over there in Lucy's house. And then, let me see. Once I stay there, she wakes me up once it gets dark, or, you know, I don't know that time span between when I go to sleep around strangers and people that I don't understand. But not strangers, but people that are bad influences. You know, it's kind of scary when you sleep around bad influences. And anyways, I go there, you know, and I stay the night. She takes me to go pick up Micah. And then, but she drops me off at Walmart. She doesn't let me go see where Stephanie lives. So I'm like, okay, why isn't she showing me where Stephanie lives? So I get a little cranky, but I don't give her no attitude. I don't show no violence because I'm not a violent person, you know? And then, yeah, I may yell just because she can't hear sometimes. And she likes to like say what to a minimum till it's like a minimum of a volume on me, you know? And anyway, she brings Micah back, picks me up from Walmart. I cooked them dinner. I cooked them burgers, Micah and Lucy and me. And once I cook food, Micah gets a little cranky, and then I'm like, why is he cranky? He I don't know, he was around those boys, and I noticed when I looked on Lucy's phone, like while before, over there when I was living over there, way before when my mom died, that was a couple years back, I noticed that Stephanie's kids smoke weed and stuff too. So I'm like, a young mom, like, oh no, you know? So I'm like, wait a minute. So I'm thinking, so whenever my son gets back, he gets mad and cranky because he probably senses the tension between me and Lucy, you know? Because she's a grandmother, but like, I'm over here trying to just live a life and she just wants me stuck here in this town. But I'm not giving up on my son, you know? So I stay here. And when I stay here, well, anyways, what was I? Oh yeah. So I'm a little upset because they claimed Micah, somebody claimed Micah on the W-2. And I asked her like, hey, did you claim him? No, I didn't claim him, but she doesn't give him money. So me and Micah get a little upset. So they're like, hey, we need stuff. We're trying to get things going, you know? And so he's frustrated because he had to go over there with kids that probably smoke weed. I don't even know. I don't have my proof on that. But he knows, and I'm the mother, and I know. So he's stealing from me. He takes my wallet, and he takes my food from me because he's trying to tell me, like, Mom, why are we back over here? And I'm over here like, son, I'm over here fighting with Lucy because she took you over there, you know? I kept telling her, can I call Michael? I want him to pick me up. No, you can't. She didn't let me use the phone either. So I get upset. And I raise my voice. That's it. And my son gets upset because he senses the tension. So he throws a lime at me. I threw a lime back. I did not slap him. And then that was whenever, okay, when me and her start yelling at each other, we start yelling at each other. I yelled at her because I got mad at her because I told her I'm fed up with this, with the W-2 and with everything, like, you know? And So when Micah heard that, I sit on the couch. Right when I sit on the couch, she's like, I'm calling the cops. Right whenever she says I'm calling the cops, Micah throws a lime at me because he's like, dude, you're gonna go to jail, mom. And I'm like, I don't want to go to jail. And as I go into jail, I sit in there in the back of the cop car, and then let me see. Sorry, I'm a little stressed. And when I sit in the back of the cop car, I see my son jump on the couch because he's trying to show me that she slapped him. And I don't slap my son, but I know when my son looks like he's gotten hurt. And he jumped on the couch before. When I was sitting in the back of the cop car. And I think the cop noticed it too. And whenever I go to jail, I go through the whole court situation. I send my lawyer a big letter explaining everything that happened. The case has been dropped.
Okay, good.
So then that's been dropped, and then he's been there for 11 months. I saved every receipt, and I'm always providing for him, always giving him food. But Lucy steps in. She just tries any loophole, anything, just to keep me here whenever we're just trying to get out of here.
All right, ma'am, and what else did you want me to know?
Let me see. All I wanted to know is that I'm just a mom trying to get things together for my son and I. And yes, I look crazy and I look, but I'm just a mother that's like trying to do her best for her son, which is, that's me.
Okay,
That's all.
well, I know we appreciate that. All right, any other questions for this witness?
No, Your Honor.
No, Your Honor.
Okay. Any final arguments?
Just briefly, Judge, based on the testimony of Ms. Novato and of Ms. Hernandez herself, just based on that alone, it's my client's opinion that for the safety of Micah, that she should be the primary joint managing conservator. Judge, we're just here on the merits on a SAPSR. Obviously, we're not here on a termination. There's plenty of time and room for Ms. Hernandez to do the things that she's testifying to, but the time is not now. That has not happened. So we're basically asking you to keep the status quo of what's already been happening since November of 2018, which is naming my client primary joint managing conservator, the exclusive right to designate his residence, make educational decisions, and to receive child support. We're asking that the parties have the supervised visitation as requested. And Judge, I should have said this first. I'm asking that you find that my client had standing to intervene in the first place, and child support as requested.
Right, and the AG has asked for child support, insurance, and a finding of paternity. Anything else?
Yes, Your Honor. Yes, we would ask that the mother continue to be ordered to provide the insurance through the other source, through the government medical, at a cost of $0 per month. We would ask that guideline child support be set against the parents in this case. We have calculated that it would be based on minimum wage, $228 for the mother to pay each month. And because she has no other children to support, and $199 for the father. That is based on the fact that he has another support obligation. So his percentage is at the 17.5 instead of the 20.
Is there a way it could be a little less since my financial issues that I'm going through?
Okay, and I'll let you talk to me about that in just a moment, Ms. Hernandez. Okay, Ms. Reed, I'm sorry, that was 199 and 235 or?
228.
228, is that even?
Yes, I think it's 228 and then 64 cents, but we rounded down for both of them.
Okay, all right. Ms. Hernandez, what are you asking me to do?
At least 200 even.
Okay, and what are you asking me to order with Micah?
Just have Lucy hold on to him temporarily until until we have another court date, and then I do this plumbing and this electric stuff and everything.
Right, well, you understand, ma'am, that you may be able to file a motion to have this changed in the future, but that today is actually the trial. So this is the final hearing.
So what does that mean?
That this is not temporary orders, which would be just that, temporary. This is the final hearing, and
So is that like, how do you say it?
this would be the final part of this case. Now, I'm not saying that you could not at some time in the future probably have to get an attorney, but get an attorney and come back and ask to have it changed.
Okay.
But this would be the final for today. All right, anything else on either side?
No, Your Honor.
Okay,
No, sir.
all right. I've listened to the testimony carefully. I will find that Lucy Aguero had standing to intervene in this case. I will establish the parent-child relationship between Feliciano Rodriguez and Micah Rodriguez. I will appoint Lucy Aguero, Feliciano Rodriguez, and Veronica Hernandez joint managing conservators of the child. I will give all of the executive rights concerning conservatorship and education and such to Lucy Aguero. I will order the 2 hours on Saturday and Sunday supervised visitation that was requested, second and fourth weekends for the father, first and third for the mother. I will order the parties to confer about telephone contact. I'll be back I'm going to take a break in just a moment and I'll ask you to confer about telephone contact between Micah and the parents. And I'll let the parents have access to all school functions and records. And I will order the father to pay child support in the amount of $199 a month. And how old was the other child, younger or older?
5, Judge, younger.
Okay. And for Ms. Rodriguez, I will find that for Ms. Hernandez, I will find that there's a reason to deviate from the guidelines. I'm very gratified that she has employment and has kept it for a couple of months. I want her to be able to keep employment. And I think that she has some psychological issues that it's going to make it difficult for her to do that, and that the child and Ms. Hernandez and everyone else would be better if she's working at least part-time. I think her testimony was also that she sometimes is only working 30 hours a week rather, and I will set her child support at $114 a month. And the child support will begin February 1st. Okay, what else do I need to rule on?
Judge, on the visitation, you had mentioned the weekends. My client had testified to Thursdays. We forgot to testify to a day for her son, so maybe we can confer on that. A weekday.
Yes, that's good. And I think you had said first, third, and fifth for the mother, but then you came back and said just first and third, so that there would be the fifth for Ms. Aguero. All right, we're going to take a break for about 7 minutes. We'll come back at 8 after, and we'll finish this up. If you can't reach an agreement, I will make a decision, and then we'll start on the Peeler case. And rather than put you in a breakout room, actually, I can put you back in the breakout room.
Your Honor, as the ruling has been made on the support issues, may I be excused?
Absolutely.
Thank you, Your
But
Honor.
you can put my client in with her now.
Okay, then I'll put all of y'all in.
Okay, thank you, Judge.
I have to go pick up my gun. Doesn't say that.
Okay, actually, I need to move Okay, so you should have all received. Oop, no, I moved law office of Harkins to the wrong one, 5. Okay, you should all have an invitation to breakout room 5, and I'll be back in a few minutes. All right, I'm back. I don't see Ms. Cavazos, but I don't know, we need a, oh, there she is, record. Okay, were you able to come to an agreement?
Yes, Your Honor, we conferred and we agreed to Ms. Hernandez having a call every Monday, Wednesday, and Friday between 5 and 6 p.m., like one call or a FaceTime.
Okay. All right.
And
Are you still there?
Mhm.
Go ahead, Ms. Harkins.
I was just gonna say, we'll confer, my client and her son have to go pick up Micah, so I'll discuss with them when he can call. That's not as big a concern. We can do that later.
Okay, and do you want an entry date for the order?
Yes, please.
We have to have one. How long do you need?
Judge, maybe just 2 weeks.
Okay, I have an Atascosa County, we don't have to do it, but I have February 2nd. That's closer to 3 weeks, but I don't, oh, wait, no, I'm sorry. How about the 27th? Oh, it says no more settings. Okay, February 2nd.
Yes, okay.
All right. Ms. Hernandez, let me let you know what's going to happen. Ms. Harkins is going to draw up an order for me to sign, and that order will take what I have decided today and it will reduce that to writing. And she is going to send you a copy of it. If you have an email address, you need to make certain that Ms. Harkins has that. And if you, I'm not asking if you agree with the order. I know that what I rule today is not necessarily what you wanted. The only thing that you would be showing if you signed it is that you agree that what Ms. Harkins has written down is what I ordered. And if you agree with that, and I'll say the same thing to Feliciano Rodriguez, then if you will sign off on those orders, nobody needs to be here on the 27th. If you disagree with Ms. Harkins and you can't work it out and you don't think that what she has written up is what I've ordered today, then we'll have a hearing on the 27th of January. Are you both clear on that?
Yes, Judge.
I have a,
Yes, ma'am, go ahead.
I have an opportunity to change this, right? The order.
I mean, you can file a motion for a new trial. You can file an appeal. There's a lot of things you can do, but I can't be your attorney on that. But this would not be an opportunity to change things. When Ms. Harkins sends it to you, the only thing that you are being asked at that time is whether you agree that what Ms. Harkins has written down is what I ordered. Okay?
This is not signing over my rights. It's just the what she explained, right? Just the basic.
Well, ma'am, I just ruled you would still be a joint managing conservator of the child, but you would be having just supervised visitation plus telephone contact 3 days a week.
Alrighty. Joint.
So I hope y'all get that worked out. If not, I'll see you on the 27th.
I have school visitation also, right?
Second or January 27th?
I'm sorry, what did we say, February the 2nd? I'll see you all on February 2nd. All right, and Ms. Aguero, I need you to unmute your computer. Okay. I don't know what telephone you're going to use for Micah to speak with his mother on the telephone, or what computer you're going to use for FaceTime. But what I want to tell you is, let me ask, first of all, does Micah have his own telephone?
Yep. I just
yes, but it's not connected.
Okay. All right. Well, what I want to tell you is sometimes children get their telephone taken away by parents. I do that myself. I'm not at all telling you can't take your telephone away. His telephone away. What I'm telling you is you can't say his mother can't call him because you've taken the telephone away. You have to make sure that you've given Veronica Hernandez a phone number that she can still call so that she can contact Micah. And if you could just, all you have to do is just hand Micah the phone when the call starts and take it away when it finishes. And His phone is taken away the rest of the time, but it's not taken away when his mother's supposed to be calling him, okay?
Yes.
All right, thank you. Then I'll see y'all. Hopefully you get it signed up. If not, I will see you on the 2nd of February.
Yes, Your Honor. Thank you very much.
Okay. All right, so we ready to go on Peeler?
Your Honor, I think we've agreed, we haven't heard from Kiewit, but I think the other parties have agreed to move the motions to exclude Gordon Johnson to tomorrow, and we'll reset the motions that were set for tomorrow to another day, since we know you are leaving at 2 o'clock tomorrow.
Your Honor, it's Mark Guthrie. I'm sorry I didn't see the emails. I was working. We don't have any objection to that.
All right then, well, I will see y'all tomorrow, and let me look at the dockets real quickly.
I think it's pretty full.
I have an addition for LaSalle. I'm fixing to update, Judge, but they're like 5 minutes total on all of them. And one was actually dropped. So let me get that posted for you real quick. Oh, and I was just informed there might be a Wilson County edition that I have not ran yet.
Okay, well, at Escosa, it's just San Miguel. Carnes, it's two pages, nothing looks. Couple of pro se divorces, motions to compel. What does? All right.
Well, the Carnes cases has been dropped already, Judge.
Excellent.
I've got,
tomorrow doesn't look bad. I don't have the criminal docket. Judge Ellison does.
correct.
There's a motion to enforce temporary orders. 2 hours, but okay, that doesn't look bad. And those are local attorneys. Okay. All right. So we ought to have plenty of time to get that done tomorrow. Okay. All right then. So we're in recess and we'll pick this up tomorrow morning.
Thank you, Your Honor.
Thank you,
All
Judge.
right. Thank you. We'll see you then.
Judge.